All right, peace and love and prosperity to the human family. Thank you all for coming back to another one of these roundtable sessions with AMPAG, in which we discuss treaties, international law in general, amongst other things, even history. This is Wednesday. So Wednesday is usually, we call it Wild Wednesday because you never know what we're going to talk about on Wednesday, but Sundays is treaty class specifically every Sunday. However, today we'll be going over the France versus United States case from the International Court of Justice. And let's begin by examining the title. Who on the line has any doubt, or even in the public, who has any doubt that this soil that's currently misnomered as the United States of America, who has any doubt that this land is Morocco? Or any questions in regards to that fact, that this is Morocco? Anyone?
I have a question.
Yes, Sister Makara.
No, that wasn't Makara.
Story.
Oh.
Shame on you, Wazir. You don't know the voice of your Sarah.
I'm sorry. I'm sorry. I'm gonna take my fez off on that one.
Earlier, I don't know if it was today or yesterday, but sometime recently, Brother Ben, he shared a link about over here being Little Egypt, and it was called Tamaray. Okay. And then I went and did my own research on that, and there are a lot of Moors, instead of calling it Tamaray or Morocco, they're calling it Tamaray. So I didn't know, maybe you could open up on.
I could tell, what I can tell you is that this is ancient Egypt. This is the original Egypt. This side of the world was here before, but not here before, but it was in dominance. It was a dominant side of the world before you saw anything in the East. In fact, you'll find 2,000 pyramids on this side of the world in Amexem, northwest, southwest Amexem, than you would in Africa. In Africa, you find 300 pyramids. There's, like the Prophet Noble Ali said it. He said there's pyramids up and down the Mississippi River, which they are. A lot of the golf courses are mounds that are being covered. That's why you see the T is like a round mound type of thing. It's all covered. So this is definitely, for sure, for what I understand, well, not for what I understand, I would say specifically saying for what Assir the Duke of Tears teaches, you would say that you would find vowels on this side of the continent, on this side of the world, on the western side of the world, and on the eastern side of the world, all they would have is consonants, right? So therefore, this side will be Egypt, and that side will be Kemet. Or no, I'm sorry, this side will be Kemet, and that side will be Egypt. So Kemet being spelled K-E-M-E-T, over there Egypt, E-G-Y-P-T, something to that effect. I've never seen that as a reference point. That's just something that Assir the Duke of Tears brought out. But this is definitely the ancient side of the world. Pyramid of the Sun in the Yucatan, up down there in Mexico. If you're not familiar with what I'm saying, you'll see it in those Aztec movies. That pyramid is older than every other pyramid in Africa, like by thousands of years, actually. So
yeah, we know they switched everything, right? East to west, north, south, up, down, inside out. Yep.
They switched everything around, and you know, the real history of this land is very well hidden. This is what they're taking these death oaths to not reveal who the true heirs and inhabitants, the indigenous peoples of this land are, and what is the land, and the things, all the history dealing with this land.
And excuse me.
Go ahead.
When that point comes to my mind, this is the promised land. This is why everybody in the world, when they want a better life, a better existence, freedom, etc., where they come over here.
That was the point that I was about to make next. What I was going to say is exactly that. They don't go to what they call the Holy Land, which they claim is Israel. That's not where they go. They come here. Everybody comes here. This is the promised land.
Yeah.
This is Turtle Island. This is the land of milk and honey. At one point, this land was in secret when we were in power in Andalusia, Spain, the Iberian Peninsula, until we fell in 1492. That's why Columbus got lost several times trying to come over here, and he had to petition the assistance of the Moors to navigate him here. And he didn't even come to the mainland. He stopped at the islands. You know, so this is, yeah, there's something special about this land. They've been trying to conquer this land for the longest, since the 15th, 16th century.
And that doesn't have to even be the Albions. It could, some of the Moors were trying to conquer.
It's not some, all of them. That's exactly the very next point that I was going to make. I was
I don't mean to be reading your mind, brother.
Oh no, you're still in my thoughts, because that's exactly what I was going to say. You know, the word colonist, colonizing, that's an act, a verb, not a people. So Moors have been more. Look, what the so-called Caucasians know, they learned it all from us, good, bad, and indifferent. All the good, all the bad, the colonizing, the enslavement, they learned it all from us because we did it to them. And we taught them all the lessons. So yes, they've been trying, when I say they've been trying to conquer this land, I'm not even talking about the Caucasians. I'm definitely speaking about other Moors from other territories and other jurisdictions. That's for sure. So the reason why I was asking, is there anybody, if anyone has any doubt that we are in Morocco, then just read this title. Sister Makara, please read that title for me.
I can't because I'm on my phone.
Okay, no problem. I got you. I'll read it.
I can read it.
Go ahead, good brother. Go ahead, good brother.
International Court of Justice, year 1952, August 27th, 1952, case concerning rights of nationals, the United States of America in Morocco, France versus United States of America.
What was the key word in that statement?
United States is a carpet.
Nope, that's not the key word. In Morocco.
Yeah.
Hey, that's what I meant. It's a carpet, meaning they in Morocco, but they hiding everything under it.
It's a blanket over Morocco. It's the artificial grass, and Morocco is the organic soil. So if anyone has a question or there it goes right there. The Treaty of Madrid. Let's go to the Treaty of Madrid. I've got it pulled up already. That's a hell of a treaty. Let's go to the title. What'd that say? What is that? What does that say at the very top right here? Right of protection where? Oh, you don't see it. Oh man.
In Morocco, right of protection in Morocco. Is that what it
correct? Says? That's what it says. I don't know why it does this. Why when you go to another document and stop sharing? I don't get it. You see it now? Yeah. Right of protection in Morocco. Case concerning rights of nationals of the United States of America in Morocco. France versus United States of America. United States of America. Now, keep in mind, as we go over this document, France and the United States both are using the same laws to make their defense. What laws do you guys think they're using? Moroccan laws. They're using Moroccan treaties. They're using our laws to make their respective cases. While the Moors who wrote those laws are doing what? What are we doing? Sleeping. Economic liberty without any inequality. Look at how it starts off. This is how this document starts off. Economic liberty without any inequality in Morocco, in the General Act of Algeciras, effect of establishment of protectorate thereon, effect of discrimination on validity of residential decree of December 30th, 1948, regulating imports. Let me blow this up a little bit more so you all can see it. Okay, consular jurisdiction in French zone of Morocco as based on bilateral treaties, most favored nation clauses, and multilateral treaties. Meaning of dispute in Treaty of 1836 between Morocco and the United States, whether applicable to criminal and civil matters. Effect of renunciation by the states of consular jurisdiction. So you see how they keep talking about consular jurisdiction. Effect of Convention of Madrid, that's the Treaty of Madrid, right of protection in Morocco, and Act of Algeciras on consular jurisdiction, custom, and usage. What is customs and usage? Customs and usage. Go ahead.
Common law?
Common law, no.
Commercial?
No. Customs and usage is, okay, I'll give you an example. The United States are accustomed to ruling us, right? But they don't necessarily, they rule us by law. A lot of what they're doing is illegal because it violates human rights. But in actual, but from the perspective that they are the only competent power because we went to sleep. So there's only one competent power. Someone has to maintain order on the land, the laws and order. So they've been doing so, right? But it doesn't mean that that's their sovereign authority. The sovereign authority belongs to the Moors. So when the Moors come back into power, then that sovereign authority automatically reverts back to the Moors. But the United States would argue that they should be able to maintain their jurisdiction over us based in customs and usage, because they're accustomed. It's a custom, right? They're used to the custom. What custom? The custom, the comfortability, the custom of ruling us. Go ahead, good brother Hakeem.
Islam. The practice that was in place and customary for a period of time, that is for such length that it has the effect of law.
There you
So
go.
they've been ruling over us, doing what they do for so long that it has the effect of law,
Yes.
even though it technically isn't.
There you go. That's customs and usage. And they're trying to claim customs and usage, and that got rejected. Thank you very much, good brother Hakeem. The writer. Okay, so that's customs and usage. Right of assent to Moroccan legislation. Right of assent. That's another argument that the United States was making. That one is going to be an interesting one. Keep that in mind. We'll go over it. Right of assent to Moroccan legislation as corollary of consular jurisdiction. Assent necessary for application of Moroccan law in consular court. Okay. In other words, what that's saying is that we require the United States permission to enact Moroccan laws. That's what the right of assent means. Ridiculous, because we don't require their permission to do anything. If anything, they require our permission to do things. We have the power of the right of assent, not them. Local laws. Somebody else said something?
No, I'm agreeing. I'm just
Okay. Local laws contrary to treaty rights. Fiscal immunity as based on Convention of Madrid and Act of Algeciras and most favored nation clauses. Interpretation of Article 95 of Act of Algeciras. So we'll go over, let's see, the judgment or the judges, President Sir Arnold McNair, judges, blah, blah, blah. We'll continue. In the case concerning the rights of nationals of the United States of America in Morocco between the French Republic, represented by M. Andres Gross, professor of the faculties of law, as an agent, assisted by Paul Reuter as assistant agent, and by Henry Merchant, Minister Plenipotentiary as counsel, and by M. Laverne, et cetera, and the United States of America, represented by Mr. Adrian Fisher, agent, Joseph Sweeney, Seymour Rubin, member of the Bar of the District of Columbia as counsel, et cetera. These are the United States Consulate General, Casablanca. These are the agents for each state, representing their states. The court, composed as above. So let me go back up. So I believe these are the judges. No, they're not. I think the judges was further up. All right. Okay, the court, composed as above, delivers the following judgment. On October 28, 1950. So it started in 1950. The Chargé d'Affaires AI of France, that would be like their ambassadors or whatever, plenipotentiary, Chargé d'Affaires of France to the Netherlands, filed in the registry on behalf of the government of the French Republic an application instituting proceedings before the court against the United States of America concerning the rights of nationals of the United States of America in Morocco. So what, they took them to court on our behalf? That's basically what that's saying. The application referred to the declaration by which the government of the United States of America and the French government accepted the compulsory jurisdiction of the court in accordance with Article 36, paragraph 2 of the court's statutes. We have seated, we've got an accession document ready to be sent out for the accession to the court, to the statutes of the ICJ or the ICJ statutes. Gratitude, brother Amaru, for putting that together. He's the Minister of Foreign Affairs. It also referred to the Economic Cooperation Agreement of June 28, 1948 between the United States and France, and to the treaty for the organization of the French Protectorate in the Sharifian Empire, signed at Fez on March 30th, 1912, between France and the Sharifian Empire. We've never heard these terms. In the regular Moorish paradigm, the old paradigm, you don't hear the term Sharifian Empire. Nope. It's all over the documents, though. It mentioned the Treaty of Peace and Friendship of September 16, 1836, between the United States and the Sharifian Empire, as well as the General Act of the International Conference of Algeciras of April 7, 1906. Pursuant to Article 40, paragraphs 2 and 3 of the statute, the application was communicated to the government of the United States as well as to the states entitled to appear before the court. It was also transmitted to the Secretary General of the United Nations. I got something hit me. So I'm about to say it. So Moors out here will get onto you and call you all types of dirty Moors if you speak on things that the prophet didn't bring.
Yeah.
Right? Well, the prophet, he never called this the Sharifian Empire.
Nope.
So because the prophet doesn't call it the Sharifian Empire, it's not the Sharifian Empire? Or should we ignore the fact that it's also called the Sharifian Empire just because the prophet didn't call it that? This is sheer ignorance and incompetence, because the prophet also said, study, study, study. Did he not?
Mm-hmm.
And if you had studied and you studied and studied, you would have came across the term on your own, Sharifian Empire. See, Moors are limited to study, study, study as it relates to United States statutes and codes and history and biology.
And the Moorish Science Temple of America literature.
Moorish Science Temple of America literature, but they won't cross over into international law and treaties for some reason. They'll study everything else. They study Kemet, they study all the other countries, they study all the history in the world. Metaphysics, everything. They study everything else but international law. That's amazing. I mean, that's got to be by design. We're being blocked from studying international law. Yeah.
Yeah.
So yeah, so the prophet didn't bring that. So what does that mean? This is not the Sharifian Empire? No, it's the Sharifian Empire. The prophet just didn't mention that because again, the other half hasn't been told. Who knows what the other half was and what he was getting ready to reveal to the people once they were ready. Because when he first came, we weren't ready. You can't you can't go from Negro blacks colors to operating government. You got to know who you are first. So that you then would know what you're doing within your government and how to hold these people accountable and why it is that you can hold them accountable. But if you're thinking you're Negro black colors from Africa, then it's not going to compute that they should be paying you taxes on this land because this land is yours. So first we have to bring you into the understanding, understanding, and overstanding of who you are, what your flag look like, what your custom is, what your culture is, what is your divine creed. This is why they call us 3/5 of human beings. Why they call us 3/5? Because we were missing 2 other elements to make you a whole. What were those 2 other elements? Your nationality. Okay, y'all, Macabre, you're gonna have to get used to this because something is the deal with my internet. Oh, I gotta hide that. Okay, so what are the 2 other aspects that were missing to make us whole beings? What was the other?
The international.
What was that?
The international aspect.
No, that's what's missing to make us full, competent government officials.
Nationality and divine creed.
That nationality and your divine creed. Islam. Those were the 2 other elements that were missing to make you whole. Right? And that's what was hidden from us. And that's what the prophet brought to us to make us a whole. Right? And then from that point, then you move on to statehood. But you don't just jump from Negrodom, right? From thinking you're coming from Africa straight to running Moorish governments. Come on now, that wouldn't even be sensible. That's why the first half was told and the second half hadn't been told. And he also said, if I told you the other half, I'll put you to sleep. Think about people who think that they come from Africa and that they're Negroes, blacks, and colors, talking about the Act of Algeciras and the Treaty of Madrid, man, they're going to sleep. They wouldn't even see themselves in it. Okay, what was that? Pursuant to Article 40, paragraphs 2 and 3, yeah, I already read those. The time limits for the deposit of the pleadings were fixed by order of this November 22nd, 1950. The memorial of the French government, which was filed on the appointed date, quoted several provisions of the Act of Algeciras, of the General Act of Algeciras, and drew conclusions therefrom as to the rights of the United States. The construction of a convention to which states other than those concerned in the case were parties being thus in question. Such states were notified in accordance with Article 63, paragraph 1 of the statute. For this purpose, notes were addressed on April 6, 1951 to the government of Belgium, Spain, Italy, the Netherlands, Portugal, the United Kingdom of Great Britain, and Northern Ireland, and Sweden. These are all the signatory powers that's part of the Treaty of Madrid, as well as the Act of Algeciras. Imagine that. On June 21st, 1951, within the time limit fixed for the deposit of its counter memorial, the government of the United States of America filed a document entitled Preliminary Objection. The proceedings on the merits were thereby suspended. The preliminary objection was communicated to the states entitled to appear before the court, as well as to the states which had been notified of the deposit of the application pursuant to Article 63 of the statute. So you have to deposit your applications. And like, what is an application? Well, your constitution is an application, right? Legislation is an application. These proceedings, thus instituted by the preliminary objection, were terminated following a declaration by the government of the United States that it was prepared to withdraw its objection, having regard to the explanations and clarifications given on behalf of the French government, and following a declaration by the French government that it did not oppose the withdrawal. An order of October 31st, 1951, placed on record the discontinuance recorded that the proceedings on the merits were resumed, and fixed new time limits for the filing of the counter memorial reply and rejoinder. The counter memorial and reply were filed within the time limits thus fixed. As regard the rejoinder, the time limit was extended at the request of the government of the United States from April 11th to April 18th, 1952, by order of March 31st, 1952. On April 18, 1952, the rejoinder was filed and the case was ready for hearing. Public hearings were held on July 15, 16, 17, 21st, 22nd, 23rd, 24th, 26th, and 26th, 1952, during which the court heard M.M. Andre Gross and Paul Reuter on behalf of the French government, and Mr. Adrian Fisher and Mr. Joseph Sweeney on behalf of the government of the United States. And the conclusion of the argument before the court, the submissions of the parties were presented as follows. So we'll be going over the arguments. But notice that, notice the language that's being used here. Counter memorial, rejoinder. We've got to get used to these languages. This vernacular, this new vernacular. The prophet said, you change the literature, you change the people. This is the literature that you need. We've already mastered statutes, codes, municipal law as a whole. We've already mastered the U.S.A. codes and their constitution and UCC laws, and we've mastered that. We know the legalese. Don't they say, don't say you're driving, say that you're traveling, right? What else they say? Never say I understand, because then you fall under the jurisdiction. Like we've learned legalese on the low level. It's time to raise our degrees and start learning international law principles and make that part of our vernacular. On behalf of the French government, may it please the court to adjudge and declare that the privileges of the nationals of the United States of America in Morocco are only those which result from the text of Articles 20 and 21 of the Treaty of September 16, 1836. And that since the most favored nation clause contained in Article 24, let's do this. Let's do this real quick. I knew I was missing something. Hold a second, hold that thought. Come on. Pull up. All right. Let's pull up. Oh, I don't have it here. I know where I can get it. I'm gonna pull up be patient with me real quick. Let me pull up. Shoot, where is it? Be patient with me here. Excuse Zillow, I'm always on Zillow.
Don't worry about it. Just do what you gotta do.
Looking for deals. All right. Let's pull up the Treaty of Peace and Friendship. And go to 1836. You want 1836. All right, so it said Article 20 and Article 21. Can y'all still see my, nope. Okay, so you can see my screen now. Article 20. All right, so let's go back and refresh. So it said that the privileges of the nationals of the United States of America and Morocco are only those which result from the text of Article 20 and 21 of the Treaty of September 16, 1836, and that since the most favored nation clause contained in April 24 of this said treaty can no longer be invoked by the United States in the present state of the international obligation of the Sharifian Empire. What does it say? Let's go to what does it say? So it says, Article 20, if any of the citizens of the United States or any persons under their protection. Let me move this out of the way. Of their protection shall have any disputes, any disputes with each other. The consul shall decide between the parties. And whenever the consul shall the consul shall require any aid or assistance from our government to enforce his decisions, it shall be immediately granted to him. So the consul or consular court has the final say in any dispute between a citizen of the United States and a Moorish national. That's what it's saying with that's what the ICJ is pointing out. On well, not the ICJ, but France is pointing that out. What were you saying, sister?
When he said in the document where it says it's any person, that's what that wrong with me. Persons, because again, that's United States citizens, not people.
Correct. And also persons is also our states. It's a state. According to the Montevideo Convention, a person is a state. Okay, Article 21, what does it say? Let's read Article 21. If a citizen of the United States should kill or wound a Moor, or on the contrary, if a Moor shall kill or wound a citizen of the United States, the law of the country shall take place and equal justice shall be rendered. The consul assisting at the trial, and if any delinquent shall make his escape, the consul shall not be answerable for him in any manner whatever. Those are those two articles, and this is what France is bringing up against the United States. Article 24.
And when it says, because Jay, I was listening to a video by him, and he brought out that same information you're talking about, and when he said the law of the country, he said that means Moroccan law.
Yeah, exactly. Thanks for pointing that out.
Because the country Morocco, that's right.
Thanks for pointing that out. Because look at what it says. If any American citizen shall die in our country, our, that's a possessive term. Oh, you are. Our. We wrote it. Just like Article 20, go back to Article 20, where it says, or assistance from our government. And whenever the consul shall require any aid or assistance from our government to enforce his decision, it shall be immediately granted to him. So it's us talking to them. All right. Thanks for pointing that out, sister. 24. If any differences shall arise by either party infringing on any of the articles of this treaty, peace and harmony shall remain notwithstanding in the fullest force until a friendly application shall be made for an arrangement. What is the friendly application? Legislation. And until that application shall be rejected, no appeal shall be made to arms. Right? So we can't be going to war. Right? It says until that application shall be rejected, no appeal shall be made to arms. And if a war shall break out between the parties, 9 months shall be granted to all the subjects of both parties. What are the both parties? United States, Morocco. To dispose of their effects and retire with their property. And it is further declared that whenever indulgence in trade or otherwise shall be granted to any of the Christian powers, the citizens of the United States shall be equally entitled to them. So now let's go back. So this is what France, this is their opening argument to the United States. So let's go over it again. That the privileges of the nationals of the United States of America in Morocco are only those which result from the text of Articles 20 and 21 of the Treaty of September 16, 1836, and that since the most favored nation clause contained in Article 24 of the said treaty can no longer be invoked by the United States in the present state of the international obligations of the Sharifian Empire, there is nothing to justify the granting to the nationals of the United States to the nationals of the United States of preferential treatment, which would be contrary to the provisions of the treaty. Let's see. That the government of the United States of America is not entitled to claim that the application of all laws and regulations to its nationals in Morocco requires its express consent. So that's what the United States is saying, that we require their consent to enact Moroccan law. That the nationals of the United States of America in Morocco are subject to the laws and regulations in force in the Sharifian Empire, and in particular, the regulation of December 30th, 1948 on imports not involving an allocation of currency without the prior consent of the United States government. That the decree of December 30th, 1948, concerning the regulation of imports not involving an allocation of currency is in conformity with the economic system, which is applicable to Morocco according to the convention which bind France and the United States. I forgot the name of that convention. They'll be talking about it though. That Article 95 of the Act of Algeciras defines value for custom purposes as the value of the merchandise at the time and at the place where it is presented for customs clearance. That no treaty has conferred on the United States fiscal immunity for its nationals in Morocco, either directly or through the effect of the most favored nation clause. That the laws and notice that they're not calling us Moors, right? They're using terms like nationals in Morocco and all that stuff, but they invoked Article 21, and in there they call us Moors.
Question.
In other words, they know who we are. Go ahead, sister.
Now, you just brought up about they're calling us national, which sparked, when you go to the heading of that document, it says nationals of the United States.
Okay, yeah, what about it?
So are you talking about two different nationals? Because when you're talking about nationals of the United States, you're not talking about Moorish nationals.
Well, the United States got their own nationals.
Huh?
The United States got their own nationals, but if you're talking about the title, that term national is referring to the Moors.
Well, if you're talking about the title and that term refers to the Moors, it's confusing to me because of that preposition means belonging to or from the United States.
Well, it says case concerning, I hate to go back up. Let me go back up.
Because when you said nationals again and you refer to the Moors, I'm saying, okay, because it only mentioned nationals in the heading, it says of the United States. Those are not, it says nationals of the United States of America and Morocco.
Mm-hmm.
Let's talk about United States nationals.
Well, if you put the whole thing into context, it's the case concerning rights of nationals. They're talking about our rights, the rights of the nationals of the United States of America and Morocco. So those nationals that are of the United States of America are the nationals who have been naturalized in the United States, so they become part of the United States of America. Because remember, we were
okay. All right. I get you.
Yeah, because remember, we were naturalized against our consent and against our will.
But that would encompass us and them.
Say it again?
That would encompass us and them.
It could.
U.S. citizens.
Well, it could. It could encompass them. But when you go through as you're going through the treaties, or not the treaty, the document, you realize more and more that it's talking about the Moors, because you'll see as I continue going, this is where you'll start seeing the differentiation when they start calling us, when they start using terms like Moorish subjects or Moroccan subjects and proteges.
All right.
That's where you start really seeing the differentiation. But then they also say terms like United States nationals. The United States nationals are the citizens of the United States, not us.
Right. That's what I was thinking of the heading. That point right there. Yeah.
Right, but the heading, yeah, but the title itself is they're talking about the rights of nationals. but which is they're not. This is not a matter of any concerns with their nationals, with their citizens, but the more subjects. Because keep in mind that France, through the French Protectorate and the Fez, the Treaty of Fez, France was given like a power of attorney, basically, you could say, right, to have protections over the Moors. That's why you have the rights of the Treaty of Madrid, the right of protection in Morocco. And then you got France. Their job is actually to protect us. I cannot remember the name of the document. Jay Bay went over it, in which the French. In fact, I got it. I got the document. Actually, we can go over that document.
You know, the French Protectorate, right?
Not the French Protectorate. Yeah, I think yeah, it is. It's the French Protectorate.
Well, I get what you're saying. I'm just saying that.
No, I got what you're saying. It's all good. No, it's all good. You made me pull it up. No, we got to do that.
You want that clarification, yeah.
Yeah, you need that clarification. Because you see right here, it says, if you can see it, right? I'm gonna blow it up.
I'm gonna make my phone.
Oh yeah, you can't really see. Okay, but everybody else can see. Turning. So this particular document is correspondences between the French ambassador of the Secretary of State of the United States and the French ambassador over a period of time, back and forth correspondences. So the initial correspondence began with the French ambassador to the Secretary of State on January 8, 1913, French Protectorate in Morocco, relinquishment of extraterritorial jurisdiction by certain foreign powers, attitude of the United States. This is the attitude of the United States. And so it's a back and forth correspondence. So you see first is France, and then here comes, this thing is all in the way. And then here comes the United States, the Secretary of State to the French ambassador. And I'm skipping over some things because I want to get straight to something here real quick. But so the Secretary of State to the French ambassador said, "Excellency, I have the honor to acknowledge the receipt of your Excellency's note of the 8th instant, transmitting the text of the Franco-Moroccan Protectorate Treaty signed at Fez on March 30th, 1912. See, that's the Protectorate Treaty. That's that Treaty of Fez, right? And then you keep going, but I want to get to a certain point. And then so the French Chargé d'Affaires to the Secretary of State, right? So the paragraph prior was the United States. Now it's the French going back to the United States. And then here comes the acting Secretary of State in response to the Charge d'Affaires. And this one is when he says something very interesting. Yeah, this is it right here. This is where the document opened up at. So you see that it says the acting Secretary of the State of the French ambassador. Oh, I'm sorry. The acting Secretary of State to the French ambassador. This was in February 13, 1914, Department of State. I'm gonna skip over all this. I'm gonna go straight to something. Look at what it says here. Turning first to the subject of the revision of the protégés list, because they was asking, the French government was asking the United States for a protected list, a list that is pursuant to the Treaty of Madrid, Article 7 and 8. They're supposed to provide a list. We've put together a list that we're going to get ready to send out to them, a list of our protected nationals, and we're going to request one in return. And that's a whole nother story. It's policy, it's processes, it's political processes. But anyhow, so it says, turning first to the subject of the revision of the protégé list mentioned in Mr. Pettit's note of September 14, it is proper to state that the protection of native Moors, this is the Secretary of State talking to the French. So if anyone has any questions, if anybody want to question that they know who we are, there it goes right there. They know exactly who we are. That the protection of native Moors in Morocco by this government rest upon its treaty with Morocco of 1836 and the Madrid Convention of 1880. The relevant part of the treaty of 1836 is found in Article 15, which reads as follows. Merchants of both countries shall employ only such interpreters and such other persons to assist them in their business as they shall think proper. And then he goes on to say, the Convention of 1880 declares in Article 1 that the protection of the native Moors is based on the British and Spanish treaties with Morocco and on the Convention of 1863 between France, Morocco, and the other powers. I'm not going to go any further. I just wanted to show and prove here what they think of us or how they know they know who we are. This is the Secretary of State to the French, calling us native Moors in Morocco. So then we go back to the case concerning rights of nationals of the United States of America in Morocco. Back to the point. Where was I? You made me lose my place, Makara. Do you remember where I was? I remember where I was.
You got it.
I'll remember. I was talking about the French on behalf of the French. Okay, right here.
Yeah.
Yeah, I was going into the United States. But did I answer your question a little bit?
Yes, yes.
Okay. That the laws and regulations on fiscal matters which have been put into force in the Sharifian Empire are applicable to the nationals of the United States without the prior consent of the government of the United States. And I hear what you're saying in terms of the confusion that it poses. I know what you're, yep, exactly. That consequently, consumption taxes provided by the Dahir of February 28, 1948. A Dahir is a royal decree from a king or a sultan. That's what a Dahir is. Have been legally collected from the nationals of the United States and should not be refunded to them. So what nationals were they talking about, right? Were they talking about the nationals of the actual United States nationals, their citizens? I would presume so. That's exactly what it sounds like to me. If anyone has any rejections to that notion, then come on in. You ain't even got to raise your hand because I probably won't see your hands anyway. All right. So anyone who has a question, concern, comment, just interrupt. No problems. On behalf of the government of the United States. 1, the submissions and conclusion presented by the French government in this case should be rejected on the ground that the French government has failed to maintain the burden of proof which it assumed as party plaintiff and by reason of the nature of the legal issues involved. 2, the treaty rights of the United States in Morocco forbid Morocco to impose prohibitions on American imports. Now you see now, come on now. We see just reading that alone, you automatically see that we're talking about two parties, two different jurisdictions that has been identified. The representatives of the United States have identified it. It's Morocco and the Americans. Moroccans and the Americans, two different jurisdictions. You can't be a Moorish American.
That's right.
The treaty rights of the United States in Morocco forbid Morocco to impose prohibitions on American imports, save those specified by the treaties, and these rights are still in force and effect. The Dahir of December 30th, 1948. See, I just went over that here on the last document that the French Protectorate document. The Dahir of December 30th, 1948, imposing a prohibition on imports is in direct contravention of the treaty rights of the United States, forbidding prohibitions on American imports, and the French government by applying the Dahir of December 30th, 1948 to American nationals without the consent of the United States from December 31st, 1948 to May 11, 1949. Violated the treaty rights of the United States and was guilty of a breach of international law. So the United States is saying that they violated their treaty rights and that it was a breach of international law. Well, let's see how the judges feel about that. American nationals cannot legally be submitted to the Dahir of December 30th, 1948 without the prior consent of the United States, which operates to waive temporarily its treaty rights. So in this case, I believe they're talking about the Moors. because they're talking about that they required their prior, we required their prior consent. So it says American nationals cannot legally be submitted to the year of December 30th, 1948 without the prior consent of the United States. They're trying to say that we got to get permission from them to do stuff, and that's not so, or at least not in our proper status. Now, in our improper status as Negroes, Blacks, Colors, Moorish Americans, African Americans, etc., then yes, you got to get permission for everything.
So are you saying in that document, they refer to us as United States nationals in our foreign state, but they refer to us as Moors in our de jure state? Is that right?
That's not specific. That's not specifically what I'm saying. Not, or at least not as it relates to this document.
Okay.
You're going to be able to identify which one they're talking about based on the context of the reading.
Yeah, I get the context, but you know, we have been taught that words are important, and
Yeah, they
words,
are.
you know, to discredit us or to misplace us, we have to pay attention to that, and that's why I was harping on that, because I'm trying to get that settled in my own mind in essence.
Yeah, we do have to. We have to be very mindful of that. But the real identity, you would start seeing.
I hear what you're saying.
You'll start seeing it towards the end. No, keep, it's all good. Whatever questions, continue asking.
Yeah,
but
I'm going to read this again after we're done with this. I'm gonna read it again by myself.
Yeah, read it again. Yeah, by all means, do that, study it. But I know when they say things like United States nationals, they're definitely talking about their citizens. But American national can be definitely be applied to their citizens because we're not Americans.
Because they're talking about the de facto land.
Correct. Well, no, they're talking about a jurisdiction is what they're talking about. It's really more about it's more so dealing with jurisdiction. So if we have been nationalized in the United States of America, not nationalized, naturalized, then we fall under the jurisdiction, the American jurisdiction. But we're still nationals, right? So they will, perhaps they would address us as American nationals. But again, the contents of the reading will really give you the proper clarity as to who they're talking about. So 3, the jurisdiction conferred upon the United States by the treaties of 1787 and 1836 was jurisdiction, civil and criminal, in all cases arising between American citizens. See, this is the United States talking, and they didn't complete the statement because it's between American citizens and Moors. But they just said, and between American citizens. In addition, the United States acquired in Morocco jurisdiction in all cases in which an American citizen or protege. See, so the protege are the Moors, the American citizens are their citizens. In addition, the United States required in Morocco jurisdiction in all cases in which an American citizen or protege was defendant through the effect of the most favored nation clause and through customs and usage. Okay, such jurisdiction was not affected by the surrender by Great Britain in 1937 of its rights of jurisdiction in the French zone of Morocco. So what they're saying here is that Great Britain have surrendered their jurisdiction in the French zone of Morocco or in Morocco way back in 1937. But by 1956, France had pulled out and all the other signatory powers had already pulled out as well. The only ones that was left is the United States. That's covered in this document. Such jurisdiction was not affected by the surrender. Okay, I already read that. And then we go on. Such jurisdiction has never been renounced expressly or impliedly by the United States. Under the regime of extraterritorial jurisdiction, now exercised by the United States in Morocco. So like they tell you, they're telling you what it is right here in this document. You know, it's like full disclosure. Under the regime of extraterritorial jurisdiction, now exercised by the United States in Morocco, United States citizens are not subject in principle to the application of Moroccan law. I'll repeat that again. Under regime of extraterritorial jurisdiction, now exercised by the United States in Morocco, United States citizens are not subject in principle to the application of Moroccan law. Not true. Such laws become applicable to the United States citizen only if they are submitted to the prior assent of the United States government, and if this government agrees to make them applicable to its citizen. So it's
Amen.
go ahead. Who's saying something? Oh, okay.
This
So
is the United States talking again, right?
this is the United States talking, and
Okay.
they're saying that in order for Moroccan law to be applicable to them, we require their prior permission, and they have to give us the permission. So it's
They're so cocky.
what was that?
They're so cocky.
Oh yeah, they're arrogant. Yeah, you know, they're arrogant as hell because we're asleep. I mean, you know, of course they have a reason to be, but they're losing that power. So they about to eat some humble pie real soon here.
Thank you.
Under the regime of extraterritorial jurisdiction now exercised by the United States and Morocco, United States citizens are not subject in principle to the application of Moroccan laws. Such laws become applicable to the United States citizens only if they are submitted to the prior assent of the United States government and if this government agrees to make them applicable to its citizens. The Dahir of December 30th, 1948, not having been submitted to the prior assent of the United States government, cannot be made applicable to the United States citizens. Yeah, right. Is a counterclaim. Under Article 95 of the Act of Algeciras, the value of imports from the United States must be determined for the purpose of customs assessments by adding to the purchase value of the imported merchandise in the United States the expenses incidental to its transportation to the custom house in Morocco, exclusive of all expenses following its delivery to the custom house, such as customs, duties, and storage fees. It is a violation of the Act of Algeciras and a breach of international law for the customs authorities to depart from the method of valuation so defined and to determine the value of imported merchandise for custom purposes by relying on the value of the imported merchandise on the local Moroccan market. The treaties exempt American nationals from taxes except as specifically provided by the same treaties. To collect taxes from American nationals in violation of the terms of the treaties is a breach of international law. So see, like
there it's clear. Yeah, I hear what you're saying. Yep.
You see what I'm saying? Yeah. Such taxes can legally be collected from American nationals only with the previous consent of the United States, which operates to waive temporarily its treaty right, and from the date upon which such consent is given, unless otherwise specified by the terms of the consent. Consumption taxes provided by the Dahir of February 28, 1948, which were collected from American nationals up to August 15, 1950, the date on which the United States consented to these taxes, were illegally collected and should be refunded to them. This is the United States talking about France, because France was getting at them with these taxes. It was making them pay taxes according to the treaties, according to the Act of Algeciras, because the Sultan gave France the authority over the French zone in Morocco through the Treaty of Fez.
Yes.
Since Moroccan laws do not become applicable to American citizens until they have received the prior assent of the United States government, the lack of assent of the United States government to the Dahir of February 28, 1948, rendered illegal the collection of the consumption taxes provided by the Dahir. These people something else.
Yeah, they are.
These people something else.
Yeah.
So when you see these three stars, this is in the good brother Jay Bay, when you guys get your states together and you get to work with him on checking the boxes of integrity of domain, the integrity of your domains, which is setting up all your laws and stuff, you'll be receiving judicial order documents from him, and this is exactly how it's structured. He's got the document structured just like the ICJ has their structure. Very fascinating. The brother is very well sharp, very well studied, and he's sharp as I don't know what. Okay, so the court will first deal. So this is now the court. So when you see them 3 stars, they're switching. The subject matter is changing. The court will first deal with the dispute relating to the decree issued by the Resident General of the French Republic in Morocco, dated December 30th, 1948, concerning the regulations of imports into the French zone of Morocco. The following submissions are presented. On behalf of the government of France, that the decree of December 30th, 1948, concerning the regulations of imports not involving an allocation of currency is in conformity with the economic system which is applicable to Morocco, according to the convention which bind France and the United States. On behalf of the government of the United States, the treaty rights of the United States in Morocco forbid Morocco to impose prohibitions on American imports, save those specified by the treaties, and these rights are still in full force and effect. The decree of December 30th, 1948, imposing a prohibition on imports is in direct contravention of the treaty rights of the United States, forbidding prohibitions on American imports. Now, look how they argue in the United States, trying to argue and complain about some damn prohibitions, like they didn't impose prohibitions on us on our own.
At the same time, they're arguing.
Boy, these people something else. Wow. The French government contends that the decree of December 30th, 1948 is in conformity with the treaty provisions which are applicable to Morocco and binding on France and the United States. This contention is disputed by the United States government for various reasons. The court will first consider the claim that the decree involves a discrimination in favor of France, which contravenes the treaty rights of the United States. By the year of September 9, 1939, His Sharifian Majesty decided as follows. So this is, look at what they said. His Sharifian Majesty decided as follows. Wow. You really gotta, it's wow. Like this is the level of respect they have for our empire. You know, Article 1. It is prohibited to import into the French zone of the Sharifian Empire, whatever may be the customs regulations enforced, goods other than gold in any form. Article 2. The Director General of Communications may, however, waive this prohibition on entry as regards combustible solid mineral matter and petroleum products. And the Director of Economic Affairs may do likewise as regards any other products. Article 3. It is left to the decision of the Resident General to determine the measures whereby the provisions herein contained shall be put into effect. So that's the judges quoting those 3 different articles from the Dahir. A residential decree of the same date laid down the terms of application of the Dahir, including provisions relating to request for a waiver of the prohibition of imports. Article 4 provided, goods of French or Algerian origin shipped from France or Algeria shall for the time being be admitted without any special formalities. Further regulations were prescribed by a residential decree of September 10th, 1939, subjecting imports without official allocation of currency to special authorization. Article 7 provided in its first paragraph, commercial arrangements with France, Algeria, French colonies, African territories under French mandate, and Tunisia are not subject to the provisions herein contained. What it says. By a residential decree of March 11, 1948, a new Article 5 was added to the decree of September 9, 1939. Article 5. Save for such exemptions as may be specified by the appropriate heads of departments, the prohibition on entry shall hereafter be generally waived as regards goods imported from any origin or source, when import does not entail any financial settlement between the French zone of the Sharifian Empire, France, or any territory of the French Union on the one part and foreign territory on the other part. Finally, this new Article 5 was revoked by the decree of December 30th, 1948, which is the subject matter of the present dispute. After having referred to the Dahir of September 9, 1939, and to the decrees of that date and of March 11th, 1948, the Resident General of the French Republic decreed, Article 1, the provisions of Article 5 of the aforesaid residential decree of September 9, 1939 will cease to apply as from January 1st, 1949, save for the exceptions set out in Article 2 thereof. Article 2, goods which are proved to have been shipped directly to the French zone of the Sharifian Empire before January 15, 1949, shall still fall within the provisions of Article 5 of the aforesaid residential decree of September 9, 1939. The effect of this decree was to restore the import regulations introduced in September 1939. Imports without official allocation of currency were again subjected to a system of licensing control. But these import regulations did not apply to France or other parts of the French Union. From France and other parts of the French Union, imports into the French zone of Morocco were free. The decree of December 30 of 1948 involved consequently a discrimination in favor of France, and the government of the United States contends that this discrimination contravenes its treaty rights. It is common ground between the parties that the characteristics of the status of Morocco as resulting from the General Act of Algeciras of April 7, 1906 is respect for the three principles stated in the preamble of the act, namely the sovereignty and independence of His Majesty the Sultan, the integrity of his domains, and economic liberty without any inequality. The last mentioned principle of economic liberty without any inequality must, in its application to Morocco, be considered against the background of the treaty provisions relating to trade and equality of treatment in economic matters existing at that time. Maybe I should read this again.
Maybe we should break down paragraph by paragraph, do you think, maybe?
Say it again.
Break down paragraph by paragraph, and like when you read
Well,
a
I could do
paragraph.
that, but if I did that, oh Lord, I'll be here forever trying to figure, because this is a long one, 46, 42 pages. But I can't necessarily break down every single paragraph, but I need questions. I would need questions.
All right, all right.
But this right here, it is common ground between the parties that the characteristics of the status of Morocco as resulting from the General Act of Algeciras of April 7, 1906, is respect for the three principles stated in the preamble of the act. So when you read the Act of Algeciras in the preamble, it talks about exactly what they're saying: the sovereignty and independence of His Majesty the Sultan, the integrity of his domains, and the economic liberty without any inequality. The judges are pointing out the triple principles, but they're really highlighting economic liberty without any inequality, because we're talking about the effects of the decree was to restore the imports regulations introduced in September 1939. Imports without official allocation of currency were again subjected to a system of licensing control. This entire paragraph is dealing with economic liberty and economic liberty without any inequality, meaning that you're talking about taxes, imports, taxes from imports and things of that nature from engaging in commerce. And that's why it's breaking down, and it brought up, they brought up the triple principles with a highlight on the economic liberty without any inequality phase of the operation.
And that's because I'm thinking that's because United States is using the domains, they're using the land, et cetera, for their commerce, but they don't want to pay anything. They just want to reap the benefits, but they don't want to pay any of the costs.
That's exactly correct. They're operating the triple principles. They've established their sovereignty and independence. Now in doing so, they created, they fortified their integrity of domains. What is the integrity of domains? Your laws. They got 1 million laws on the books. What else? What else gives their where else do they established their integrity of domains? Miseducation. Miseducation, especially of the Moors.
Health system.
Exactly, but more so, but the reason why I'm saying miseducation is because if the Moors knew who the Moors were, then they wouldn't be able to maintain integrity of domains.
That's correct.
They needed us to not know who we were.
We were. That's
And
right. That's
so
right.
in addition to us not knowing who we was, they also established a bunch of laws that kept us in place, that kept us locked in, that controlled us.
Yep.
So that's how they established their integrity of domains. And then the sovereignty and independence naturally comes after. This is where you're talking about all the taxing and the licensing and the revenues that they generate from the people, or in general. That's integrity of domain.
Yeah.
Or economic liberty without any inequality. So that's why here that says, so they're highlighting it. So they said the last mentioned principle of economic liberty without any inequality must, in its application to Morocco, be considered against the background of the treaty provisions relating to trade and equality of treatment in economic matters existing at that time. It's like, wow, it's just fascinating. This is a fascinating read. By the Treaty of Commerce with Great Britain of December 9th, 1856, as well as by treaties with Spain of November 20th, 1861, and with Germany of June 1st, 1890, the Sultan of Morocco guaranteed certain rights in matters of trade, including imports into Morocco. These states, together with a number of other states, including the United States, were guaranteed equality of treatment by virtue of most favored nation clauses in their treaties with Morocco. On the eve of the Algeciras Conference, I can stand it. Yeah, something is up with this. Are you guys there?
We're here.
Okay, good. Let me reshare the screen. This is annoying. Okay. Okay, by the treaty conference with Great Britain. Yes, go ahead.
Abdul,
Go ahead, brother.
are you
You sound far. Come to the phone. You sound far, brother. I can't hear you.
hold up. Are you connected wirelessly or hardcore with your laptop? Hard connect.
Well, that's a good point. I guess I could do a hard connect because I'm done. I'm with wired. I'm wireless. So I probably should do hard connect and it won't happen. That would start happening.
Exactly.
Which means I need to find the cord. I ain't got time to stop and go look for it. So I'll keep that in mind for the next one.
Yeah, for the next one, hard
Yeah.
connect. That's how you ensure integrity.
Yeah, Islam. Appreciate that. That's a good point. I never thought about that one. All right, by the Treaty of Commerce with Great Britain of December 9th, 1856, as well as by treaties with Spain of November 20th, 1861, and with Germany, these states, together with a number of other states, including the United States, were guaranteed equality of treatment by virtue of most favored nation clauses in their treaties with Morocco. So all these states had a most favored nation clause within their treaties. I don't know why the Sultan gave them that kind of authority, but you know, a lot was taking place in this time where the empire was fractured and it was losing its power. The final blow was the loan that they received from France in 1910. They received a loan from Spain in 1904, and they went into default, I believe. And no, that's what happened. And in 1910, France gave them a loan to pay off that loan. So it was the empire was financially dependent upon the European powers. And
part of that, why were they so independent on the European powers? Is that because we were asleep and not doing our part to collect taxes and revenue and all of that?
That's one part of it, but the other part is also that the Sultan was a belligerent and he wasn't doing the right things with the finances, with the revenues.
Ah, okay.
See, it had a lot to do with his operations more so than anything else. You know, he was I read in one of these classes, I read about the young Sultan that came in after his uncle passed or something. We'll go over it, and I forget his name. It's in the book, the Passing of the Sharif and Empire. And the young Sultan came in and he was just building. He built a railway inside of a building, the royal building.
So he was just going crazy with finding money,
Yeah,
like a spoiled child.
that's what I'm saying. He was like a little 22-year-old, and the Europeans, they took advantage of his age and his lack of wisdom, and you know. So that's part of the reasons why. But keep in mind that we had already failed. We first began falling in 1940, in 1492. When we fell to Queen Elizabeth and Queen Isabella and King Ferdinand. But they didn't put the nail in the coffin until the early 1900s, late 1800s, early 1900s with these loans. So it really took them 800 years to finally fully subjugate us. It took them 800 years to fully subjugate us. That's fascinating. It took them that long. That's how powerful we were as a people. But as a people though, as the Aboriginal and indigenous Moroccans, Moors here in Morocco, we had failed sooner, earlier than 1800, like 1700s or so. I know the prophet said that slavery lasted from 1779 to 1865. You know, that was the time of slavery. But even before then, we were still subjugated mentally even. The Dred Scott case does anybody remember what year the Dred Scott case was? I know the Sundry Freemore Act was in 1790. You see? So in 1790.
Dred Scott was 1857.
1857. And then, so 1857, Sundry Free Moors was 1790. And why did they petition South Carolina? Because they were trying to hit them with the Negro codes, the Black codes, the Negro laws.
Black Christian code.
The Black Christian codes, right. So you're talking about 1700. So
1724.
What was that?
1724.
What is 1724? You talking about the Christian Black codes?
Yeah.
Right. 1724.
And we want to be Christians. We end up being Christians. That's funny.
Well, that's due to the Negro, the Negro preachers, the Reverend, the Reverend pork chops out there.
Yeah.
You know, they put us into that mindset, and that's been going on since late 1600s, mid 1600s. So we had already started falling as a people, but the empire as a whole started really, really fracturing later on in the late 1800s, early 1900s. That's why they was calling us Moorish subjects and Moroccan subjects and proteges, because we had already been subjugated and defeated. So, you know, the empire was the last stronghold, was the last stand. So Boabdil, back in 1942, he was a belligerent, gave up the daggone keys to the city, to the kingdom. And then here we got these later sultans with their BS. Keeping in mind also that these sultans were of a lighter complexion.
Yes, they were mixed or not really of our bloodline.
Right. The later emperors, sultans.
They may not. That's right. They may not have had. Probably did not have the matriarchal bloodline.
Probably not, because if that was the case, then that young sultan wouldn't have been spending like that, doing the things that he was doing.
Yep.
You know, by that time, they may have already then destroyed the matriarchal principle in our society, in our empire.
Yep.
On the eve of the Algeciras Conference, the three principles mentioned above, including the principle of economic liberty without any inequality, were expressly accepted by France and Germany in an exchange of letters of July 8, 1905, concerning their attitude with regard to Morocco. This principle, in its application to Morocco, was thus already well established when it was reaffirmed by that conference and inserted in the preamble of the Act of 1906. It's in the preamble. Considered in the light of these circumstances, it seems clear that the principle was intended to be of a binding character and not merely an empty phrase. So this wasn't just an empty phrase. The triple principle is a binding, it has a binding character to it. You know, you're required to establish your sovereignty and independence, integrity of domains, and your economic liberty without any inequality.
So it's not a saying. It's not a rule. It's a principle.
Exactly. And so if everybody else in the world, if all the signatory powers had to apply by that, what do you think the Moors got to do?
That's right.
All right. So, and then they go on to say, this was confirmed by Article 105, where the principle was expressly applied in relation, in relation to the public services in Morocco. So it says, this was confirmed by Article 105. So this was confirmed by Article 105. Article 105. With a view to assuring the application of the principle of economic liberty without any inequality, the signatory powers declared that none of the public services in the Sharifian Empire can be alienated for the advantage of private interests. This is what they referenced. The judges referenced this. This was confirmed by Article 105, where the principle was expressly applied in relation to the public services in Morocco. It was also confirmed by declarations made at the conference by the representative of Spain, who referred to equality of treatment in commercial matters, as well as by the let me repeat that, who referred to quote unquote, quote, equality of treatment in commercial matters, end quote, as well as by the representative of France. The establishment of the French protectorate over Morocco by the Treaty of March 30th, 1912, that's the Treaty of Fez, between France and Morocco, did not involve any modification in this respect. In the convention between France and Germany on November 4th, 1911, concerning the establishment of this protectorate, the government of Germany made in Article 1 the reservation that the action of France should secure in Morocco economic equality between the nations. You see, so they have remixed economic liberty without any inequality. They done remixed it. They call it an economic equality between the nations and whatever else but it's still the same principle. On the other hand, the government of France declared in Article 4 that it would use its good offices with the Moroccan government in order to prevent any differential treatment of the subjects of the various powers. The other, are you hearing me? The other states on behalf of which the Act of Algeciras was signed, with the exception of the United States, adhered later to the Franco-German Convention of 1911, thereby again accepting the principle of equality of treatment in economic matters in Morocco. France endeavored to obtain also the adherence of the United States, and in a note of November 3rd, 1911, from the French ambassador in Washington to the United States of America, to the United States Secretary of State, reference was made to the Franco-German Convention. It was declared that France would use her good offices with the Moroccan government in order to prevent any differential treatment of the subjects of the powers. In another note from the French ambassador to the Secretary of State dated November 14th, 1918, it was declared that the benefit of commercial equality in Morocco results not only from the most favored nation clause, but also from the clause of economic equality, which is inserted in the Act of Algeciras and reproduced in the Franco-German Convention of 1911. These various facts show that commercial or economic equality in Morocco was assured to the United States, not only by Morocco, but also by France as the protecting state. So see, that's the thing. France through the French protectorate, they were protecting the United States and the sleeping Moors. They were protecting everybody, or supposed to have been. That's what they were entrusted to do. It may be asked whether France, in spite of her position as the protector of Morocco, is herself subject to this principle of equality and cannot enjoy commercial or economic privileges which are not equally enjoyed by the United States. So that this is the judges, they're questioning this.
Mhm.
It is not disputed by the French government that Morocco, even under the protectorate, has retained its personality as a state in international law. Let me read that again. It is not disputed by the French government that Morocco, even under the protectorate, has retained its personality as a state in international law. The rights of France in Morocco are defined by the Protectorate Treaty of 1912. In economic matters, France is accorded no privileged position in Morocco. In economic matters, France is accorded no privileged position in Morocco. Such a privileged position would not be compatible with the principle of economic liberty without any inequality, on which the Act of Algeciras is based. This was confirmed by the above mentioned note from the French ambassador in Washington of November 14, 1918, where it is stated that by virtue of the clause of economic equality inserted in the Act of Algeciras, other states have preserved their right to enjoy such equality. Mimi vis-a-vis de la puissance protectrice. Huh. That's French. I just tried to do my best French rendition in reading it. And that the United States can, therefore, not only recognize French courts in Morocco, but also give up in the French zone the enjoyment of all privileges following from capitulations without thereby losing this advantage. It follows from the above mentioned considerations that the provisions of the decree of December 30th, 1948 contravene the rights which the United States has acquired under the Act of Algeciras, because they discriminate between imports from France and other parts of the French Union on the one hand, and imports from the United States on the other hand. On the other, France was exempted from control of imports without allocation of currency, while the United States was subjected to such control. This differential treatment was not compatible with the Act of Algeciras, by virtue of which the United States can claim to be treated as favorably as France, as far as economic matters in Morocco are concerned. So they're fighting for an equality because France was charging them taxes.
Mhm. And they're trying to say that France was in equal standing with them and not above them.
Correct.
To them to do, and basically they were both looking for that power and that wealth from both of them. Yeah.
That's absolutely right. And what were they using to try to establish that power? That this little back and forth they got going on. What did they use? They were both using Moroccan treaties. Our treaties.
Yeah.
They were.
Yeah, so they're fighting, just like Todd has always said, they're fighting about our states You're fighting for something that don't belong to you, none of them.
Don't even belong to you.
Mhm.
But and now the France position is that they had a specific treaty with the Sultan, the Treaty of Fez, the Protectorate Treaty,
Right.
which gave them a certain authority over of protection, but that still didn't award them any financial privileges. And so that's what the ICJ is basically pointing out.
And that was only necessary because we were still asleep.
Say it again.
And that was only necessary because we were still asleep.
That right. That right, exactly. That's the reason for that's the whole reason behind the French protectorate, because we sleep. So we needed the protections. And obviously somebody didn't trust the United States with the protections. Why? Because of the Act of Congress, the Naturalization Act, and all the things that they had done.
The Organic Act 1871, all of that, 1860, all of that stuff. Yep. That's Lincoln, all of that. Yep.
That's the reason. It was like, okay, we gotta bring somebody else in and try to hold down these Moors. This conclusion can also be derived from the treaty between the United States and Morocco of September 16, 1836, Article 24, where it is declared that whatever indulgence in trade or otherwise shall be granted to any of the Christian powers, the citizens of the United States shall be equally entitled to them. That's the most favorable clause, most favorable nation clause. Having regard to the conclusion already arrived at on the basis of the Act of Algeciras, the court will limit itself to stating as its opinion that the United States, by virtue of this most favored nation clause, has the right to object to any discrimination in favor of France in the matter of imports into the French zone of Morocco. So France lost that one, you know, in the opinion of the court.
Yeah, because they were saying, as it says in that statement, that it would be discriminatory.
Correct. And so the government of France has submitted various contentions purporting to demonstrate the legality of exchange control. The court does not consider it necessary to pronounce upon these contentions, even assuming the legality of exchange control. The fact nevertheless remains that the measures applied by virtue of the decree of December 30th, 1948 have involved a discrimination in favor of imports from France and other parts of the French Union. This discrimination cannot be justified by considerations relating to exchange control. For these reasons, the court has arrived at the conclusion that the French submission relating to the decree of December 30th, 1948 must be rejected. It therefore becomes unnecessary to consider whether this submission might be rejected also for other reasons invoked by the government of the United States. In these circumstances, the court is not called upon to consider and decide the general question of the extent of the control over importation that may be exercised by the Moroccan authorities that don't exist. You see? See, none of this, none of the case between France and the United States would have even existed
if it wasn't for the Moors.
If the Moroccan authorities was in full effect, man. Because at the end of the day, if both of those powers, France and the United States, whatever disputes they had, where would they needed to go? What is the venue for them?
The common denominator was Moroccan Empire.
Yes, but there's a specific office that I'm looking for as far as the answer.
Consular court.
Consular court.
Consular court. Yep. You're right. Consular court. And there was no consular court. Yep.
And there was no consular court. Yeah. So this is the reason. So this is the reason why they ended up having to petition the ICJ, because there was no consular court.
Yep.
If there was just one Isaac, that's who they would have had to went to. When I say Isaac, I'm just, he's the Kazi of consular court for AMPAG. But they didn't. There was no such thing. That's the reason why Dred Scott was found as a plaintiff in error. Because he petitioned the wrong court. He's
And that's the
petitioning.
same thing happening everywhere now, with all the courts everywhere with us trying to get remedy, and we're
Well, the difference now is that, I mean, you can get remedy. It's just that the problem is that we're trying to gain remedy as Moorish Americans who is rejecting the jurisdiction that you're trying to gain the help from.
right.
It's like,
Yeah. And it's individuality too, where that's why the remedy's spotty, you know?
right,
Mm-hmm.
right. Because you can gain remedies. You can get a Negro black color can get some remedies, you know, because he's a
Right.
citizen.
That's right. That's
He's,
right.
he's going to continue to be a citizen, and he's going to stand his square as a citizen. So then, as a citizen, it makes sense for you to enforce the Constitution and enforce U.S.A. code, whatever. But if you're coming in there rejecting the jurisdiction, then where's your laws?
Yeah.
You can't reject my jurisdiction and use my laws. Like, come on, man. Think of me as the Caucasian. I'm sitting on the bench, and here comes a black guy that's calling himself a Moor, a Moorish American. He's calling himself an American. His affidavit is whatever. It has the American flag on there. And then he's also preaching our laws, our Constitution, our statutes, our codes, our legislation. I'm gonna look at you like you crazy.
That's right. That's like European coming in our court with our outfits and dreads and everything else.
Right. And saying you ain't got no jurisdiction over me, but the Moorish flag is on their documents, and they trying to impose consular Moroccan laws. Like that's what we've been doing. It's just been,
you're in the wrong house, dude. You're in the wrong house. Yep.
It's been we've been on some other stuff. Our teachers, I swear, they have taken us. And I don't know, and I'm talking about, this is the VHS DVD teachers.
Yeah,
the VHS DVD teachers. They got us in there. You ain't got no jurisdiction over me. Enforce the Constitution. And my flag, your flag is on our documents. And I'm an American, or should I say Moorish American. I am an indigenous, Aboriginal, indigenous American.
But at the same time, those are the things that were pushed on us. Not only by our own, but by them too.
They didn't push none of that stuff on us. The most they did was come out with the 1828 dictionary, but they didn't push that. None of that.
That's in the school systems, and
it didn't come from the school system, sister. I'm talking about, hold on, let's clarify what the discussion is. I'm talking about the whole Moorish paradigm. None of that Moorish paradigm came from them at all, not from
no.
That's what I'm talking about. The Moorish paradigm, the whole enforce the Constitution and learn their laws, and the and the motu proprio and Moorish American and all these incompetent, with all due respect to my Moors, but it was incompetent. It was a good exercise. It serves the purpose.
It did.
It served the purpose because now you know that you got to put things on the record. You got to, there's a certain processes that you have learned through this misconcept, but it's time now to let go of the misconcepts, let go of the DVDs, let go of the VHSs, and start paying attention to international law and the new paradigm, which is based on international law and statehood. And that's not even a new paradigm. That's just a new paradigm for us Moors, but we're late to the party. Africa decolonized back in the 60s. While we were still begging to drink water out of white people's water fountains and use their services because we want integration. We shouldn't have been arguing and fussing and fighting over no damn integration. We should have been fussing and fighting about decolonization. The decolonization document came out in 1960. Yeah,
that integration really did us really harmed us a great deal. Yeah.
We didn't, but our Negro leaders was leading us into that direction. We weren't preview to understanding or even learning anything. There's nothing in place for us to learn any form of government, international law, any of that. That's why the prophet said he's going to leave the Europeans here long enough to teach you how to run governments. The prophet wants you to run governments. Good brother Hakeem Bey made that point clear in one of his articles.
Well, yeah, I read that, and it's absolutely correct that we have to learn how to run government. That's correct.
Well, that's going back into the ancient mind, the ancient minds of
But
the
what is
forefathers.
good, what the blessing is that we're learning it now.
Well, we're the last one to come. That's what I was saying earlier. We're the last one to the party, and you know how they say, save the best for last, baby. 'Cause us, us being the last one to the party is the nail in the coffin. So we're the last to the
Yeah.
party for a reason.
Yeah.
So it's all in divine timing. I mean, you got the
It
brother,
is. It is
got-
in divine. That's right.
you got the brother from Akampong, Akampong, the state of Akampong in Jamaica, the Maroon brother, Chief Curry,
Mhm.
Chief Richard Curry. I big them up. You know, they're standing on the square of a treaty. I can't remember the name of the treaty, but it's a treaty between Great Britain and the Maroons, which which is a misnomer. They're really Moors, and
Yeah.
and that is Morocco over there as well.
Yes.
Anyway, let me see. It's 9:10. Is what it looks like. No, 9:20. Okay. I'll continue on for a few more minutes till about 9:30, and then we'll shut it down for questions, comments. Let's build. All right. So here it goes. The court will now consider the extent of the consular jurisdiction of the United States of America in the French zone of Morocco. The French submission in this regard reads as follows. So now they're talking about consular jurisdiction. Haha, our favorite discussion. That the privilege of the nationals of the United States of America in Morocco are only those which result from the text of Articles 20 and 21 of the Treaty of September 16, 1836, and that since the most favored nation clause contained in Article 24 of the said treaty can no longer be invoked by the United States in the present state of the international obligations of the Sharifian Empire, there is nothing to justify the granting to the nationals of the United States of preferential treatment, which would be contrary to the provisions of the treaties. So in this case, when they're talking about the United nationals of the United States, they're clearly talking about their citizens. The United States submission concerning consular jurisdiction reads as follows. 3, the jurisdiction conferred upon the United States by the treaties of 1787 and 1836 was jurisdiction, civil and criminal, in all cases arising between American citizens. In addition, the United States acquired in Morocco jurisdiction in all cases in which an American citizen or protege was defendant through the effect of the most favored nation clause and through custom and usage. See, they trying it now. Such jurisdiction was not affected by the surrender by Great Britain in 1937 of its rights of jurisdiction in the French zone of Morocco. See, like they keep talking about these rights to extraterritorial jurisdiction and civil and criminal jurisdiction. You don't have any rights for that. Not like that. Not, you know, the only reason why it exists with you is because we sleep. But if we were awake, this wouldn't even be a discussion. It's acquiescence. You really only got it from through acquiescence.
Yep.
Go ahead, sister. You have something else?
No, go ahead.
Okay. Such jurisdiction was not affected by the surrender by Great Britain in 1937 of its rights of jurisdiction in the French zone of Morocco. Such jurisdiction has never been renounced expressly or impliedly by the United States. So that's the United States talking, but that's still the ICJ. They're just repeating what the United States said. It is common ground between the parties that the present dispute is limited to the French zone of Morocco. It is on this ground that it has been argued the court cannot therefore pronounce upon the legal situation in other parts of Morocco. In order to consider the extent of the rights of the United States relating to consular jurisdiction, it has been necessary to examine 3 groups of treaties. The first group includes the bilateral Treaty of Morocco with France, the Netherlands, Great Britain, Denmark, Spain, the United States, Sardinia, Austria, Belgium, and Germany, which cover the period from 1631 to 1892. It's a long time. There's a lot of treaties. And that's with us. And all those countries and all those states that I just mentioned are in the empire. Different jurisdictions, different setups, but it's within the empire. But then again, when you study the, chapter 47 of the Circle 7 Quran, all of the world is Morocco. So, all right. So these treaties, which were largely concerned with commerce, including the rights and privileges of foreign traders in Morocco, dealt with the question of consular jurisdiction in 3 different ways. 1, certain of the treaties included specific and comprehensive grants of rights of consular jurisdiction to the powers concerned, e.g. the treaties with Great Britain of 1856 and with Spain of 1799 and 1861. Also keep in mind that, the treaty, let's make that point real quick. Let me go back. So it's between 1631 to 1892. Keep in mind that the powers, the heads of state in this time period, specifically in the earlier time period of 1631 and so on, these people look just like you and me. Let's keep that in mind.
Yep. That's right. That's right.
All right. You got your French Negroes, your French Moors,
Right.
Portuguese Moors,
Germans. That's right.
Belgian Moors,
Yeah.
German Moors.
Yeah.
Right? That's why the good brother Jay Baby saying that the term Moor is a generic term.
Generic term. Yep.
It is. You got to specify what type of Moor.
Yep.
You got your Brazilian Moors, you got your Panamanian Moors, you got your Denmark Moors, you got your Spanish Moors, you got your
Moors, yeah.
Australian Moors, Chinese Moors, and then you got your Moroccan Moors. So which Moors are we? Moroccan Moors, baby. You Moroccan Moors. Certain of the treaties included specific and comprehensive grants. I already read that. No, grants of rights of consular jurisdiction to the powers concerned, e.g. the treaties with Great Britain of 1856 and with Spain of 1799 and 1861. Certain of the treaties made strictly limited grants of privileges with regard to consular jurisdiction, e.g. the treaties with the United States of 1787 and 1836. There were other treaties which did not define in specific terms the treaty rights granted by Morocco, but instead granted to the foreign nations through the device of most favored nation clauses, the advantages and privileges already granted or to be granted to other nations. There is a common element to be found in the most favored nations clauses, which have brought about and maintained a situation in which there could be no discrimination as between any of the powers in Morocco, regardless of specific grants of treaty rights. When the most extensive privileges as regards consular jurisdiction were granted by Morocco to Great Britain in 1856 and to Spain in 1861, these inured automatically and immediately to the benefit of the other powers by virtue of the operation of the most favored nation clauses. That was a mouthful. The second group consisted of multilateral treaties. So let's clarify bilateral and multilateral. There's only 2 types. Either it's bilateral or it's multilateral. Bilateral is 2 nations on the contract, i.e. the Treaty of Peace and Friendship between the United States of America and Morocco. 2 parties, bilateral. And then the multilateral is 2 or more. 2 or more countries or 2 or more states. In this case, when they refer to the multilateral, they're talking about like they're saying here, the Madrid Convention and the Act of Algeciras. That was between 12 powers, 13 powers if you include Morocco. Okay, and it's the same powers actually. And
they're all part of Morocco.
What was that?
Because they're all part of Morocco.
Right. And the Sultan was reigning in the order, bringing everybody together to reign in the order. And like the Madrid Convention, for example, that was necessary to give us an out. An out from what? Can anybody tell me? Charlemagne, you probably can tell me. What did the Treaty of Madrid give us an out for, especially Article 15? What took place
I
in,
know.
okay, what is it, Makara?
It was giving us an out to get out from under them and come back to our own government.
That's exactly correct. But specifically, they did something. The United States did something to us.
They changed our nationality.
Correct.
They kind of.
They didn't change our
No,
nationality.
they didn't change our
They
nationality.
They
Thank
naturalized.
you. Yeah, I was trying to say it right. Correct.
Okay, yeah, they naturalized us.
And that was with the Naturalization Act of 1870.
And they did it fraudulently.
Correct.
They did it with a pen. So how do we get out of that? With a pen?
Same way, with a pen. We
Same
just
way.
correct that fraud. That's right.
So when you look at the 101s, that's what the 101s is talking about. The cover, see, the prophet spoke in, he didn't just speak in words and in parables, he also spoke in codes and symbols, signs and symbols. So walking out, let me see if I can pull it up. I'll pull it up in a second. Let me see. It's almost 9:30.
Coming out of the water, that's
Yeah.
coming out of Admiralty.
Coming onto the south of Rock of Salvation.
Yep.
Hold on a second. Because it's already 9:30, so we can I'm gonna shut down the reading so we can get to some Q&A. But can you still see my screen? Oh, good. Y'all look this up. International Labor Organization. International Labor Organization. Let's see. What do I call it? 101 Moroccan Temple. Temple 101. Let me see if that brings it up. We'll go to the images. There it is. This is the one I got, the pink one.
Yeah, I got that one. Mine is blue though.
Then you see it. I don't know if I can. Okay, you guys should be able to see it pretty well.
If you click on this something bottom, it'll open up that picture so it's on your screen. It should be.
I knew it was going to do that. It doesn't always do that. I knew that's what you were saying, but it doesn't always do it. I don't know. It's like hit and miss.
What book is this again?
This is the 101s from the Moroccan Temple of America, the questionnaire for children, Quran questions for Moorish children, Moorish Americans.
Did you click on the picture? Just click on the picture.
I did.
Okay. Okay.
When I click on the picture, it brings me to this crap.
And there was no other option on the bottom there.
No, I don't see any other option. Let me see. I got these three: save, add. There's nothing else really I can. But you can see it okay on the screen, right?
Yeah, we can see it.
The only problem is that you can't really see the water. But if you can see my my cursor, there's water back there, and that's called the cares of the world. What law deals with water?
Admiralty.
Maritime, but UCC is dealing with what word did you say, Makara?
Admiralty.
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 Right.
Admiralty law. Maritime law and admiralty law are not the exact same things. Maritime law is the law of the sea. That's the de jure law. Admiralty law is not de jure, it's de facto. And that's what they're using.
Still law of the sea, but de facto, is that right?
Say it again.
It's still law of the sea, but it's de facto.
Yeah, right. It's law of water. It represents water coming on the land. It represents the sea coming on the land, and basically that water coming on land put Morocco underwater. So now all the Moors have drowned.
Supposedly.
So yeah, well, you know.
Yeah, in their imagination, yeah.
Right. Well, not even in their imagination. Politically, that's correct. Politically, not physically in life, because obviously we're still alive. But politically, yeah. And so that's what that represents. So that's why when we bring our Moroccan subject name or your strawman name, your all caps name into the national trust, you're bringing it out of the cares of the world, out of Admiralty law, out of United States of America municipal laws into Moroccan law.
And that's why,
Moroccan jurisdiction.
and I never could understand what the prophet meant, and I just got it, when he said, do not get rid of your Christian name.
Well, if you look back in the past, the Moors didn't do that. They just affixed their bay and their L's to their
Right,
names.
but that's what he really meant.
Yeah. Yeah, he said
Yeah.
don't get rid of it because it's a transmitting utility that you
Yes,
still need to
yes.
use
That's what he really meant.
to interface with other corporations. Right? So, so your straw man would interface with other corporations, and you, the living being, sign off on behalf of that corporation or that artificial entity or your so-called straw man, which is really your Moroccan subject. But the point that I'm making with the picture is that the prophet's entire demonstration on this picture is exactly what Article 15 represents. So it says, Article 15 says, let's blow this one up. Okay. Any subject of Morocco who has been naturalized. So it's combating the Naturalization Act, 1870. This came out in 1880. So 10 years later, the Sultan said, oh, hell no. Let's put this thing together for the Moors. Any subject of Morocco who has been naturalized in a foreign country and who shall return to Morocco shall, after having remained for a length of time equal to that which shall have been regularly necessary for him to obtain such naturalization, choose between entire submission to the laws of the empire and the obligation to quit Morocco, unless it shall be proved that his naturalization in a foreign country was obtained with the consent of the government of Morocco, which it wasn't. Right? So then you look at the picture of the prophet. You see the prophet coming out of the United States of America, the cares of the world, onto the rock of salvation, which is Morocco. And in doing so, he's carrying humanity or the mother in his arms. And AMPAG, New Mecca and AMPAG is doing that's exactly what we're doing. We're leaving out of the cares of the world, which is America. We left that. We're now standing on the rock of salvation, which is Morocco, and we are carrying the mothers. How are we carrying the mothers? Because the mothers have been entrusted and giving the position of the matriarchal council, who establish all the laws. And the matriarchal council is forbidden for the matriarchal council to bring any patriarch or any male into that council. It's only for women. Keeping in mind that any woman can be any other position. She can be the Wazir Reis or the prime minister. She can be the Qazi. She can be the minister of foreign affairs. But no man can be matriarchal council, which is the legislative branch. So there's a discriminatory element to the Constitution. However, it's for the betterment of the world, because this government, AMPAG and New Mecca, are established based on the matriarchal council, the matriarchal principle, as it should be. So you got some weird guys out there saying that we are a patriarch, we are patriarchs, and we established this as a bunch of dudes, and that you should go get a VHS and DVD. They don't know what they're talking about. They haven't done their research. And DVDs and VCRs are outdated, and nobody has those anymore. You can even play them. What's up, brother?
So with that said, Lakara, what was that question you had about with the Constitution? That you said that's a good question.
Oh, there was something in the Constitution, matriarchal and patriarchal, and it was talking about rights of if your father was a Moor versus if your mother was a Moor.
Patrilineal versus matrilineal.
Right. And it was talking about the rights of, I don't know, like maybe a position, I can't clarify, or the descendancy to inherit or something. And it said, if your father is a Moor, then the father's mother's line would be researched. But here's the thing. With the matriarchal gene, the mitochondrial DNA is only passed through the female, not the male. The male can carry it, but he doesn't pass it on.
That's why everything goes back through the mother. Even in
Right.
our history, yeah, it goes from the mother, grandmother, to great grandmother.
That's right. That's right. So I was wondering, why would the patriarchal Moors blood mother's line have to be researched in relationship to a child he had with an Albion? Because at that point, when he has a child with an Albion, that matriarchal DNA stopped. It changed. Now it's the Albion's matriarchal DNA that child's carrying.
That's what makes him a patrilineal versus matrilineal. So the matrilineal means that your mother is a Moor,
Yes,
right?
I get
Asiatic. And if you're patrilineal, that means that your father
is.
Mhm.
Right. So why would you need to research the father's mother's line relating to that child? Because that child no longer carries that mitochondrial DNA. He carries the mitochondrial DNA of the mother now.
Who's
So it's the
researching
mother.
Yeah, who's researching?
What's that?
What do you mean by
researching?
what are you trying to say when you say
That's
research?
what I'm just saying. What the document? That's what the document says. It says the mother's line. I mean, the father's mother's line would be researched. It says that in that section of that.
Right. Okay. Yeah, I recall something to that effect. And
I was wondering, why would that need to be researched? Is what I'm asking, the same thing.
why would it need to be researched?
Yes.
I don't know. I haven't even considered that. I didn't even think about that. I could ask about that.
All right.
But
because I was wondering, saying, because I know the mitochondrial DNA changes at that point. So why are we researching the father's mother's line in that instance? That's all. That's all.
Okay.
That's the only question.
I mean, to me, it would sound like to identify his true pedigree, right? I mean, if you're gonna research, if you're gonna research into the patrilineal, your patrilineal lineage, that means now that we're looking at the mother, because we know that the father is a Moor. Right?
I understand that. We're looking at the mother now because it doesn't say anything about researching the matriarchal. It only said researching the patriarchal. So I'm like, why are we researching the patriarchal in relationship to any children they have when that mitochondrial DNA has stopped? It's not in those children.
That's why, because now it's being carried on by the other woman, right? See, like the mother, the matriarch, the matrilineal or the matriarchal side, that's the divine side. That's the mother. If your mom is the Moor, there is no research necessary. It's a done deal.
But we're totally in agreement, but I'm still confused as why are we searching the father's line? Why?
Well, just take a look at the father.
What you're asking.
If the father's mother is an Albion.
Oh, I see what you're saying.
Just take it step by step. Look at the father. Who is his mother? If his mother's a Moor, no questions asked. If his mother is an Albion, there you go. Problem solved.
There you go.
Okay. All right. Thank you. I didn't think of that aspect of it.
Mom.
That's why I asked questions, and thank you for that.
That's why he's the chief judge. Go ahead, Marius.
There you go.
Can a woman be a prime minister?
Yeah.
Okay.
She can be everything. She can be the prime minister. She can be what you cannot
So
be. Go ahead.
So when we do the United States of Morocco again, we're gonna have a woman out front.
It's a possibility. There's nothing against that.
Yeah, I think that would be the matriarchal thing, and then have all the
Well,
fellas back
no, the
there.
matriarchal thing is the matriarchal thing is the Lil Aziz or the matriarchal council, the ones who are in charge of the
The
payment.
legislation. Yeah,
Legislation.
that's right.
That's the matriarchal thing.
legislation.
Anybody can be the
Yeah.
prime minister, but but nobody, not anybody can be the Lil Aziz or matriarchal council. Only the women can be matriarchal council.
No, I'm talking about the empress that represent the whole continent.
I know that's what you're
So-
talking about.
So that's
The
what I was.
sultanate. He's talking about the sultanate, right?
Huh?
The sultanate.
Yeah, I was just wondering if we're gonna, make it look like
That's no,
The
it's
beehive.
that's dependent upon whoever's running. You could have
okay.
you may have 10 people running for office to be the head of the central government. Five of them could be women, 5 of them could be men. 3 of them could be men, the other 7 could be women. Whoever runs, whoever gets elected. It's not a matter of, okay, it's only going to be a woman for this, or it's only going to be a man for that. The only case in which that
Matriarchal run government, though,
what was that?
right? It would still be basically a matriarchal form of government.
It's still a matriarchal form of government because
And that's what I mean. So that would be kind of not so important because it's still a matriarchal form of government. Yes.
yeah, it's still gonna be. It doesn't matter who's the head. What matters is who's writing the
Right.
laws.
That's correct.
Look at this one here. Look at this picture. What y'all see wrong with that picture? And they love it too.
Sheikh Ali L.
No,
And the flag is there, the United States flag.
the flags.
And the position.
What's wrong with the flags?
They're in the wrong position.
They're in the wrong
Actually,
position.
They're both up there. Yeah.
They're in the wrong position. The cherry trees to the left, the old glory, which I don't even, it's the banner, is to the right. But you
Well, we
see,
don't even know if Moore did that. Could have been an Albion.
I'm Moore did it because Moors, they fly just like that in their temples.
Really?
Oh, yes. You know how many temples they got with the Moorish flag to the right and the United States flag to the left? It's ridiculous.
Mm-mm.
But when you don't understand certain things, you don't know what you don't know. But this picture displays it better. You see how he's stepping out of the water. It says the cares of the world. Then he's stepping onto the rock of salvation. Yeah. Sheikh Ali El, I don't know who that is, but that's a good rendition of the picture because it shows it a lot better. But I don't know about this flag arrangement. That's super suspect. That's not how it goes. It's bad enough.
It shouldn't be circles around the 7 either. It's not a circle.
Exactly. I
mean, I could break that down in a million different ways. What's wrong with it? But
yeah, exactly. I didn't even see that part. Exactly. It's not a circle. It's the 4 gates.
coordinates. Yeah, the gates. Exactly.
They got a full circle. Man, get out of here. Let me click off this thing, man. It's aggravating me. I swear these Moors, man.
Good riddance.
I said good riddance. Exactly. Like, you know what I'm saying? Like some of these Moors, I swear, man, they claim they worship the prophet. Now the prophets, see, this is the way it's supposed to be. You see how that circle is? That's how that's supposed to be. You got the 4 gates. North, south.
They missed the message and worship the man.
That's right and exact right there.
That's the right and exact one. Not this crazy stuff over here. You know, but a lot of Moors, they claim that the prophet, they follow the prophet, they honor the prophet, but they don't because they don't follow. There's a lot of principles
that are wrong because the prophet's information says we're Moorish Americans.
Yeah,
At least what I know about it, it says it.
Well, it does say it, but it doesn't necessarily mean that the prophet wrote it either. Because it's nonsensical, the whole, you know, why are we Moorish Americans? Because we're descendants of Moroccans born in America. Let me see here. Let me see this right here. How do you know, let me see, maybe it's this. How can I make this bigger? Because that's, the question is right in that one. Oh, that ain't it. How do I make it bigger? I don't know. I'm trying to make this screen bigger so you can see what it says here.
I just thought that if we're a matriarchal system, then, and that's what we teach is the woman first. We come from the woman teaches us all of that stuff, then we should be led by that. And if we are led by that, everyone looking at us will start looking at us in a complete different light, as if to say, oh, woman first over there. Wow. I want to see what that's about. And it may start fixing our homes, our houses, what we're dealing with in the love life, all of that stuff.
When you mean a woman in the head position, you got to clarify a little bit more.
So if we go back and say nature, who's the head of the house? We got to go all the way back to the first house. The first woman gave birth to the first baby. She was the one running the show. I don't think that ever changes.
Of course not. No.
Right. So that's what I'm saying. Like us going about the same route that we're in today, man, masculine, testosterone, push. I think it should be female.
That's why we
Not
have
necessarily.
No, I was just personal, just saying.
Okay.
Yeah, that's why we had the Dalil Aziz and the Sayar Raha. That's the lead. I mean, that's where everything stems from.
Hey, if I could chime in, I mean, I think you're looking at it wrong because like the women are the law givers. So that's why they control the legislation. So that's why we had them in that position, because they are the ones establishing the laws. We are the law enforcers.
Exactly.
We're the ones to make sure that it's enforced, and the Qazi is the one to make sure that, you know, the consular courts or whatever, if any disputes or anything are in the midst.
So all right, let's use the history again. Mama told me to go to the store. I don't feel like going. Big bruh come beat me up and make me go to the store. Mama still ran the show.
That's right.
No, you're right. You're actually
Mama run the show.
That's what we're saying the same thing.
That's exactly how it is.
Yeah, we're saying the same thing though.
Okay.
I think you kind of focus on the cosmetics.
Right.
Like I guess like the speaker of the house or whatever, you saying maybe a matriarch or whatever. I mean, not a matriarch, but a patriarch. But he's not the one that's running the show. The women are the ones creating the laws. He's just a spokesperson for it. You know what I'm saying?
And they enforce it. They make it, put it into practice.
Absolutely. And the consular court enforces it or whatever.
Here's the other perspective that you need to recognize, brother. What happened to what's his name? Abraham Lincoln and JFK. What happened to them two?
Got assassinated.
Okay. What positions were they?
Head of state.
It was leading the charge, right? So the mother is in safety. That's why it's the matriarchal council.
Exactly.
They're in safety. You don't go messing with.
Yeah, that's us protecting.
That's exactly right. We go out there and take that's what the whole testosterone rah stuff is for. But it's not a matter of it being a dominant. The problem with with patriarchal systems is that it's being dominated by the patriarch testosterone rah stuff. But in a matriarchal society, the society is controlled or ran and operated by the mothers, and it's enforced by the sons. And that's where, in order for the sons to enforce said laws, it requires the rah testosterone. That's why they go up front. So Shaka Zulu's auntie and his mother, they drew up the war plans, and Shaka Zulu enforced it by going to war. So I've never been in agreement for the mothers or women to be on the front line with rucksacks and rifles.
Right, because they also are the creators of the nation. So if they out getting killed, ain't no babies being born.
Exactly. So they are to be kept in secret protection. Secret societies come from the mothers. That's why it's mother, son, ma, son, may, son, the mother and the son, the crescent and the crescent and the star. They're kept in protection. We out here enforcing the laws. They're the lawgivers, we're the law enforcement. So yeah, I hear what you're saying. You're looking at it a little wrong, just because you could have the head of state be a woman, but the matriarchal council would not be the matriarchal council. It could be anybody.
We're patient. Don't worry about it. We're patient.
This though, I'm glad
we're patient.
I'm glad your brother Coleman gave me the idea. I'm gonna have to use a hard line. I didn't even think about that. That was a good idea. That was a common sense idea, actually. So anyway, yeah. So how you feel about that discussion, brother Marius? Do you still feel comfortable with the matriarchal system as it is, or do you feel that? Are you adamant about the fact that only a woman should be in the head of state position?
Oh, I said when we have the United States of Morocco, you missed the beginning.
No, I did not miss the beginning. I am speaking about that. Doesn't make it. See, you gotta. Okay, this shows a little bit more that you're not. See.
No, AMPAG, so let me clarify what I'm saying. Let me clarify what I'm saying. So you know how they got the Queen of England. I don't want to call her a queen because we all know what the word queen means. So that's why I'm saying, would we have an empress? What would we have? Or is it just going to be the United States of Morocco as is?
When you say as is,
like each individual state representing itself.
Yeah, that's exactly how it's going to be. Each individual state going to be representing itself, but it's going to be under the jurisdiction of the United States of Morocco, which it may not be. That's just a placeholder name. That may not be the name. It could be, let's just say Morocco.
Yeah, right? I get that. So that's why I was just saying, is it going to just be the same, constructed the same way, or?
There wouldn't be one individual overseeing all of Morocco.
Let's look at it. Yes, exactly. Let's look at it. Let's do it this way. The prophet said, I'm going to leave the Europeans here long enough to teach you how to run government. Okay, so let's look at their government. They got 50 states that are all independent from each other, but they all fall under the jurisdiction of the federal United States of America, or the federal United States. Do you see? So the United States, are you still there? Am I still heard?
Yeah.
Okay. Yeah. So the United States is the United States is the federal, would be our central government. And then those 50 states, state of Georgia, state of Alabama, et cetera, would be our independent states. Except the difference with us is that our independent states are tied to international law by the act of ratifying, depositing, and promulgating our constitutions. So each individual state is actually an international state, whereas the state of Georgia is not an international state. It's just an organ of the United States. Their constitution was deposited with the United States, not internationally.
Right.
You feel me? So that's the difference, but that's the same concept. So that's what we're.
So like in Africa, we're gonna have 50 countries here. Basically, 50 countries.
Exactly. And that's what Gaddafi was trying to do. He was trying to centralize all 50 of those states, or however many, I think it's 55.
In Africa?
Yeah.
Yeah.
He was trying to centralize them all as under one central government.
Right.
And one currency, one law, and one everything. That's what we're planning on doing here in Morocco.
Okay.
And we already got. Go ahead, brother.
Another point of interest, I just want to change it just a little bit. When we're talking about patriarchal and matriarchal, if you think about in history, the reason why the patriarchal wanted to make that move patriarchal, because the land has always been the Moors, and the women, they control the land, because they're the creators of people, and people create nations, and that's basically the mothers. So their end was the way they took the land was actually to marry into with our women. And when and they would go ahead and kill our women, and they would take over their land that they control. And that's how they ended up taking it on a different level, like patriarchal, because now the mother who had 200,000 acres, now the husband is an albion. Now he controls that. So now he's going to marry other albions. His children's going to marry other albions, and there goes our nation gone. So that's why within our Constitution, we have things in there like, okay, if your mother's an Asiatic and your father's an Asiatic, 40%. If your father's an Asiatic and your mother's an Albion, 20%. And if their children decide to marry, that they have Albion mothers, and they decide that Albion mothers' children decide to marry other Albion siblings and stuff like that, they continue to marry, and they're gonna work themselves out of an inheritance because we're following a matriarchal system. So that's how we're protecting our nation. It's in our Constitution.
So
Great
my
point.
daughter. So question, my daughter, she married an Albion. Y'all don't say nothing, man. I ain't got time for the jokes.
No, it's so real.
No. What's gonna happen with her?
Your issue, not mine.
Let's go, man.
No, just on the real side, your daughter's an Asiatic. So she married an Albion, okay? So their children, let's say that she has a daughter. Now, it'll be wise for her daughter to marry an Asiatic because, continue that bloodline. But if your daughter's daughter, the daughter marries an Albion, then she's kind of out. You follow? You just gotta do the math. It's not that deep.
Plus the inheritance. Right. You can't even spell her without inheritance, or inheritance without her, right? The inheritance will go to the female. Right.
And if you think about it, by us focusing on as a nation, protecting our nation, there's no reason why we should get caught up in listening to some patriarchal man saying, hey, I can get you a house, I can get you some land or some buildings in this island over here, or I can get you a beautiful car. It's like, we don't want to hear that's just sand. We got the whole beach. And he just trying to offer us grains of sand, and we had the whole beach of sand. So
yeah, and unfortunately, a lot of us have taken the little sands, like the little bitty, what do you call them, granulates or whatever, the little sand. The sellouts took the sand, the little bit of sand, the little not even a handful of sand, and the whole thing belongs to us. So, but those were great points. That's a great point you made in regards to the matriarchal versus the matrilineal versus the patrilineal. That's a good point. Exactly. That's how you protect it, and that's why they don't get, the patriarch, those who fall under patrilineal, the patrilineal side of it, they don't get a full 40% from the national trust. I don't even remember what the number is. It's like 20%. Not even, it's probably more than that. Let's see.
What did you get that at? What did you read that at?
Interesting that you're bringing that up, that you're asking that, good brother. Where is it? There we go. Laws and COPA. Okay, what article is it? There you go, patrilineal. There shall be two status within AMPAG. Those statuses are matrilineal, a matrilineal national, one who is by birthright of their Moorish mother, one who has declared and proclaimed their nationality standing as a Moorish matrilineal. Let's go to we already understand what the patrilineal and the matrilineal means. Where is the national trust? Which one is the national trust? Article 6, Supreme Clause, Amendment Protocols. Looking for the national trust, should be Article 4. It sure is Article 4. So, all right. So it says here, plan for revenue management shall be as follows. From 100% of revenues in a given period, either monthly, quarterly, or biannually, as the trustees shall see fit, the revenues shall be distributed as follows. 10% to be contributed to various Moroccan Empire development funds, which support Moorish erudition, provincial government development, Moorish housing, and Moorish family support. 10% to remain as reserves in the treasury, 40% to be used for governmental management, and 40% to be distributed among registered Moorish nationals from the prior accounting period. This may also include those of patrilineal national status, yet their amount would be half that of a matrilineal national. So they would get 20%. So your question, you asked, Coleman, you asked the question, where you get it from? The Constitution, Article 4. Not Article 4, yeah, Article 4, which is the National Trust. You got that, Coleman?
Yeah, I got it.
Okay. Article 4. So they get, so anyone from the so the patrilineals get 20%, half of what the matrilineals get. And for the reasons, for example, like what Isaac said, protect the national trust, protect our wealth. Also, we may have other, like, so this is a true state government. This is a real country, if you will. So we can take in Albayans as citizens or subjects. They would more than likely they would be subjects, because in our Islamic culture doesn't deal with citizenship. So you would be a subject. Well, considering modern day rule and how things work, they may be citizens. So let's just say citizens, subjects, or whatever. Point is that they cannot be part of the matriarchal council or the Dalil Aziz. So if a so-called white female comes into the government, she would never be Dalil Aziz. In other words, she could never have the pen. She cannot have the power to make laws. Only the Moorish mothers have the right or the power to make laws. She who controls the pen controls the land. Make sense?
Yep.
All right, it's 10 o'clock. About to get ready to shit it down. Let me see. Where did we leave off with France versus United States? Page 15. Let me write that down. Page 15. Anyone else got any concerns, comments, critique? Whatever.
Yeah, it was pretty good tonight. It's some droppage.
What was that?
Yeah, it was pretty good class tonight besides your droppage.
Oh Lord, have mercy. I'm gonna go ahead and grab a plug. They done came out here, but they can't figure out what's wrong with the system. So it just is what it is. Well, this was a good class. I appreciate all the participation. A lot of good insights, a lot of great insights. I'm surprised Marius is still awake. What you doing awake, brother? You supposed to be asleep, man.
Man, they striking right now. I don't got no job.
Okay.
They striking at the ports.
So you get to chill with the Wazir for a little while longer, huh?
Yeah.
Islam Qadi.
Islam.
Marius is our Qadi. He's trying to get to the taxes. He wants the taxes and the double duties.
I hear that.
I'm trying to tax their ass 60%. All foreigners, 60%. Oh, well, go home.
So you,
Right, man. It's time, boy.
Before we go, Isaac, let me show you something, Isaac.
All right, go ahead.
Page 209. I'm showing everybody, but I'm gonna show you too, Isaac, because we discussed this and we were wondering what was the reference point. So let me take you to the reference point. Page 209. Where is it? 204.
What document? What document?
Oh, this is France versus United States.
Oh, okay.
The PDF itself has 42 pages, but within the PDF, you see at the top left corner, you see page 207, like right here.
Yeah.
Okay, so I'm looking at page 209, 208, 209 at the very bottom. Then it states, let me start from the, the four factors specified by Article 95 are consistent with either interpretation. In particular, the expression free from customs duties and storage dues affords no clear indication, because if the value in the country of origin increased by the amount of insurance, freight, etc., is to be taken as the basis. This expression means before entering the customs office and paying duties, whereas if the value in the local market is to be accepted as the basis, some such expression is necessary, or at any rate, prudent, in order to indicate that the duty of 12.5% must not be levied on a value which already contains the 12.5%. So remember we were discussing about the consumption taxes?
Yes.
There you go right there, it's 12.5%. That's our reference point. The ICJ France versus United States case. So it's 6% for the Habu use, 2% for every real estate sales, 12.5% consumption taxes. It's ridiculous. So when the prophet said, children, you are, what do you say?
Rich.
Yeah, but rich. He said another word, you are plainly rich. Plainly rich. No one can take it away from me. The prophet read the act of Algeciras. He not only did he read it, he studied the act of Algeciras. I mean, how else would he know this stuff, man? Come on, let's keep it real. This stuff will not come to you by osmosis. Someone has to put you on game.
Yeah.
You know, somebody's been putting the Africans on game. That's why the Africans were able to force decolonization and gain their independence back in the 60s when we were what? Here marching and praying, we shall overcome. Nobody was putting us on game when it comes to these international. That's sad too, but it is what it is. The time is now. Now we know. better, you do better, some more. Let's do better. Islam.
Islam.
You guys look out, everybody, anyone in the audience outside of this call that's interested in taking their allegiance to a more state government in Texas, you may want to reach out to the brother Coleman or Sister Makara. Same as Indiana, you would want to reach out to the brother Akil Bay. Indiana and Texas are coming online pretty soon.
Awesome. Awesome.
Yes. So make contact with those brothers and help them build the state. I know that Texas already, Brother Coleman or Sister Makara, go ahead and put the name of your state
in the text.
You can say it you can put it in the chat. Can somebody mute their mics? It's causing a lot of if you're not talking, just mute the mic, please. You can put it in the chat, but also verbalize it so that anyone that's watching the video can hear the name of your state and also, if possible, a contact information. Same as you, Brother Akil. I think I seen you online.
Yeah. Yep, I'm about to read my information in the chat.
But also verbalize it, because remember, the people that's watching this video, they're not going to see the chat, so they want to at least you can put it out there for them to hear it and go from there. You know what I mean? So go ahead, Coleman, you go first, brother, and then you go, Akil.
Do it for me, Makar.
D.I.D. Martis, Elorum, Morocco, Prias, Texas.
Islam. And what is the contact? It could be.
I'm gonna put it in the chat.
Okay. Well, you also have a Facebook page. It's called Moxin Dimti, right?
Yeah, D-I-M-P-T. Mm-hmm.
Islam. And they've already got a flag and a seal. They got their constitution. They're looking for a few more people to complete well, you guys got 2 or 3 branches of government. They need a couple more people to complete the roster for the state of officials. Go ahead, good brother Akil Bey.
The name of our state.
Hold on, brother. You sound bad. Try to. I don't know.
Hear me?
I hear you, but not clearly.
Just a second.
Muslims supporting Muslims. We want to build these states, y'all.
Can you hear me now?
Oh yeah. Go ahead, brother.
Okay, the name of our government is Meru State Republic. You can reach me at my email, as we don't have a Facebook or email established. My email is aqilzbey@gmail.com. And from there, you'll be able to get the information for the other people that are in the government. So anybody who is in the quote unquote Indiana territory can reach out to me, and eventually other people who are in our government is for me.
Islam.
And with that, I yield the floor.
Islam, good brother. Appreciate you. So there's Dimti and Meru. M-E-R-U? M-E-R-U, brother?
Yes, M-E-R-U.
Okay, M-E-R-U. All right.
Yeah, M-E-R-U State Republic.
Islam. So you guys contact those brothers and those.
Yeah, I'm putting my email in here in a minute. I'm on my phone, so it's taking a little while.
Okay, no problem. Take your time. So that's good. So, good works, you all. I wish you success with your states. I hope it comes online as soon as possible. But don't rush it. Take your time. It will come when it's time to come. Just keep checking those boxes as you continue moving forward. And Islam.
Hey, Makara.
Right?
You in Texas, right?
I am.
Have you reached out to Sheik Love L?
Yep. Talk to Sheik Lavelle. He goes into the Moorish Science Temple. It's the only way, and blah 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 blah.
What y'all laughing for?
They had an open mind though.
Say what? I'm
He
telling
said-
you, he's Moorish guys. How do you say a diehard fan or whatever? That's him.
Islam.
I've been there, done that.
Yeah, it's not. It's
I
not.
even was in a temple. So
Nah.
nah, that's not the way to go.
Nah.
I was about to address this good brother over here, the brother Watson Ali. He himself is a Grand Sheik.
Mm-hmm.
So he's a different type of guy. Let's just put it that way.
Mm-hmm.
Yeah, that's me. That's
Yeah,
me.
most of the temple people who are sheiks and sheikesses, they're diehard sheik and sheikesses, and you got to stay within the temple guidelines. And a lot of them work with the statutes and codes and all of that. You know what I'm saying?
Oh yeah, that's true.
They're done. Let me grab something. I'll be right back.
Yeah, because he was talking about the 98 number. I was like, I don't know 98 number.
If you do your state, you ain't gonna need that.
Right, exactly. And
the benefits will be greater.
Grand Sheik, are you familiar with this, Grand Sheik? Grand Sheik Watson, are you still there? Damn, he done dropped off at the wrong daggone time. So this right here is the divine and
He's familiar with it.
Right. This is the divine.
He's familiar with it. I got a copy of it downstairs.
Understood. I want to make a point here. The reason why I'm bringing this up. This is the divine Constitution and bylaws. If you look at Act 5, see, the main thing is that these good Moors are, I don't know where it comes from, but they have this stern belief that the temple is a state.
Yep.
Let me read Act 5. And I'm just gonna start off with the first two words. This organization. Shall I continue? This organization of the Moorish Science Temple of America is not to cause any confusion or to overthrow the laws and constitution of the said government, but to obey hereby. Or obey, I'm sorry, obey hereby. This organization. So if this was a state government, I think the Constitution would have said this state government or this anything dealing with nationhood.
Yep.
That's not what it said.
Nope.
It said this organization.
They would have. I'm gonna tell you, brother. They have a reply for that, and it's like you're in a boxing ring with them, trying to get them to understand. And it's sad, but it is. It's the truth.
Yeah, I'm not going to be boxing. I ain't going to be going back and forth at all.
Mm-hmm.
I'm done.
Because I've been there, done that, and I tried. I really did. I'm like, I'll wait until you get your consciousness is more aware. Then we'll try it again.
Yeah, well, this is not for everybody, but I will end that discussion by saying this. The same prophet that they, I say the word worship. They worship the prophet. The prophet said himself, do not worship me, study and carry on my laws. And I'm not speaking about anyone particularly. I'm just speaking about those who carry this specific mentality. If you're clinging on to the words of the prophet, then cling on to these words. I am going to leave the Europeans here long enough to teach you how to run government.
But again, they'll bring it right back to that we are a government. We have our constitution. We have what they say here it is. This is what Lavelle said to me. Have you heard about it's a theocratic state? That's what he says. Yep.
I know.
And then he starts to spew. He goes on, and he'll talk for 15 minutes before he can get a word in proving his point.
He's not the only one.
Mm-hmm. He's not the only one. It's correct. It's correct. Yes, that's right.
Most of the Grand Sheiks are saying that stuff. It's a theocratic government and it's ran by Allah.
Yeah. They take the Christian church and they kind of mix it. Yeah,
Islam.
that's absolutely. And the codes and statutes and all that came with it. They're Moorish American. They're still saying they're Moorish Americans.
Listen, mother. Everyone has their right to self-determination.
I was there. I did that too. Just like AMPAG said, been there, done that. But I recognized there was a problem. There was something wrong, and there was something not quite right.
The sister, did you introduce them to the AMPAG videos? Did the Grand Chief?
I mentioned them. I always mention them.
You got to get them to look at them videos.
Brother Ben, I've had a conversation with the brother.
Oh, you know him? He still ain't listen to the videos. Okay, enough said.
Part of it is that they're so invested in so much time and energy preaching this and living this and being this and expounding it to everyone that it's hard for them to step off it or step back without, in their eyes, I'm thinking, looking like they're foolish or something. To me, that's progress. To me, that shows your growth. That's all. Yeah.
Well, our Grand Sheik, we got a Grand Sheik, and he came in with his eyes wide open, seeing and knowing. I mean,
a wise man doubteth often and changes his mind, and fool is obstinate and doubteth not and knoweth of all things but his own ignorance.
Islam.
Got to grow and unfold as there's the bud unfolds to show the flower.
Yes.
Islam.
Yes. As you go down that road, it keeps unraveling in front of you.
That's right.
Islam. The prophet says, study, study, study.
Study.
They don't want to study. They just want to remain in fellowship and worship. And I don't, I'm not going to.
But you know what? The prophet also said, and I see the different aspect of this, where he said, if we all woke up at one time, we tear shit up.
Yeah.
So, and that is true. So we have to have some of us wake up now and some of us wake up later.
That's true.
Yeah.
And he also said that Moors are hard-headed.
That's true too. Oh boy, we got so much stuff to maneuver, and that's why, out of all the peoples on the planet, our situation and who we are is so unique.
It is, which is why we're the last ones. Which is why we're the last ones to the party.
Yeah.
And you can, and again, for the record, you can best believe that your grand governors and your grand supremes, whatevers, the higher ups, they good. They don't even pay taxes.
Oh yeah, I know that's right.
They're holding on to some information that they're blocking us. They're blocking us. People are blocking us. I don't trust none of them.
But also in this divine movement, divinely speaking, they're getting their benefits now.
Yeah, they're getting their benefits now.
They're getting their benefits now.
501c3, 805.
That's right. And so in the future, they can't be living. They're not going to be like us.
Well, they're ipso dromore subjects, and they're under the jurisdiction of AMPAG. If you in Georgia, you're under our jurisdiction, according to let's share the screen. So on our way out, let's share the screen. Let's share the screen. Article 102, Act of Algeciras. That was written by the Sultans.
Can you make it a little bigger? Because I'm on my phone.
I will.
Thank you.
Let me try to. Oh shoot. Okay.
Oh, I'm in the wrong
one. Okay. Can you see it?
Yes. Thank you.
I'm trying to get this thing to drop so I can reach the. Oh, come on, go down. This little bar be popping up. I'm trying to get it to go down so I can access the scroll mechanism. Every confiscation. You see how it's off to the right? Let me bring it down a little bit because I can't.
Yeah, I see that. Yeah, that's perfect. That's good.
Okay.
That's good.
Every confiscation, fine, or penalty must be imposed on foreigners by consular jurisdiction and on Moorish subjects by Sharifian jurisdiction.
Awesome. Yep.
But they fall under our jurisdiction
That's right.
as more subjects.
That's right. That's right.
Islam. It is what it is. So they want to be Moorish Americans, let them be.
Mm-hmm.
They don't want to study. They don't want to study the Europeans to learn how to run governments. Let them be. They want Allah to be the one running the government, and okay, well, let them be. That's whatever y'all want to do. Yeah. I'm over here.
Yeah.
I'm over here. Y'all do whatever y'all want. I'm over here. I ain't. So it's been over 100 years, and the same thing is the same thing, and nothing has changed. There's no remedies. There's no remedies. There's no remedies. I can't go to the temple for any remedies. But it's not a bashing on the temple.
Well, yeah, they're making small gains in like small little things, but you know, those things also are used against us in a way, to keep the confusion.
Yeah. The ones with all the benefits are the Grand Shiki guys.
Yeah.
So it is what it is. It just is what it is. That, you know, let's get off that subject. Because I don't
well, anyway, that is the
everybody
response I got from Brother L when I brought this up to him, and that was recent. That was very recent.
Yeah, I'm pretty sure I got the same response basically. But he was open to learn about the act of the service, and I shared it with him. Did he read it? Probably
I don't know.
not. Probably not, because it's not the Circle 7 Quran. So if it ain't that, then they're not going to read it. So it is what it is. I did my part, and I'll give you the reference points one time, and if you're gonna reject it, then I'm cool. You know, move on to the next. All right, it's 10:30. I don't want to keep this going too long because then the video will be too long. And you know, our people got a short attention span for some reason. Any other final comments? Points of discussion, points of interest?
Good.
All right, brothers and sisters, divine mothers and sons, we appreciate you all for being on the line. Participation. Sunday, we'll be going over Charlemagne. Which one did you say? You said consular. You said Vienna Convention on Consular Courts? On consular relations?
Yeah, that's the one from 1969.
Yeah, so Vienna Convention on Consular Relations, 1969. We'll begin that particular reading on Sunday, and next Wednesday we'll continue with France versus United States of America. Islam.
Islam.
Oh, love everybody. Have a great evening, and we'll see you same time Sunday. Peace and love.
Wait. Question.
Yes.
Can someone please send to my email the link, because I don't like looking on the phone. I'd rather use it on my computer.
Oh, okay. I'll send you the link via email.
All right. Thank you.
All right, no problem, sister. Peace and love.